originating summons suit has already been admitted by your lordship, subject to scrutiny by the department. Now, my lord, scrutiny has been completed and the defendant has already entered appearance. They have informed us that they have entered appearance in the matter. Now, my lord, direction is required, my lord, to file written statement, my lord. That's why I am mentioning the matter.
My lord, may I have my lord's leave to mention a matter on the original side for filing of a leave to file a plaint and a petition with the tender number. My lord, I will serve and the matter may come with the liberty to for the matter to appear on Monday, both the plaint and petition, my lord.
Why?
There is urgency insofar as the matter pertains to certain amounts which have been siphoned off from the plaintiff's account.
May I have your lordship's leave to explain, my lord? I am leading Mr. Das in the matter. My lord, my employees, I am, my lord, a large pharmaceutical company. My employees have taken out stolen money from me. I have filed criminal proceedings. They were in jail. Now they have come out. From the records of the police, we come to learn that this money which has been stolen from me, they've used this to buy 2 properties which they are in the process of selling. My lord, I'll give notice to them. And if your lordship permits the plaint and the petition to, my lord, appear on Monday, my lord.
The non-commercial?
Non-commercial.
Non-commercial. My lord, money taken out by an employee from my bank account by perpetration of fraud and passed on to 2 other persons and used to buy, my lord, 2 properties, which I want to injunct, and it's a money suit.
Monday is the non-commercial. Commercial. But it's a... Yeah, no, 10:30.
I'm grateful.
You granted.
I'm grateful.
My lords, may I mention a non-commercial matter which is coming up on 16, my lords. I want to find my written statement which is slightly delayed by 23 days, my lords. May kindly grant leave so that I can file it with the master.
Affirmed.
The written statement is affirmed already, my lords. May kindly grant.
What is this?
It's a written statement, my lords, to the non-commercial suit.
The non-commercial suit. Have you filed any application for extension of time?
My lords, earlier we had filed before the master, that has been granted, but after that also the Christmas holidays had started.
No, you have filed an application for extension of time.
Not right now, my lords.
So this is what is this?
My lords, I'm mentioning for a leave of this court to file the written statement.
Okay. Leave is granted to file in the department, subject to acceptance by the court.
Much obliged.
May I have your lordship leave to mention, my lord? This is a PLA matter, my lord. The scrutiny has been completed. Let the matter appear in the list, my lord, for
Give.
And may we permit, my lord, the interim order is expiring on 7 January 2024.
7 January, mention on that day.
Commercial list. Item number 2.
My lord, I am led by Mr. Rupak Ghosh, my lord. He's on the way, my lord. Kindly praying for a short passover, my lord.
Okay, pass.
Much.
May appear for the petitioner, my lord, the plaintiff in the suit. Now I'm moving it without a notice. The application for injunction. Now the dispute between the parties and the transactions are the plaintiff used to give money to the defendant for manufacturing of cast iron manhole covers. The defendants are manufacturers of this pig iron and they make cast manhole covers. So I pay them money and they manufacture. Now the agreement is at page 51. There are 3-4 agreements from 46 to 51 by which I will pay and he will manufacture. Now I have paid him money and he has failed to manufacture and give me back the products. Now he has stopped his foundry and he is no more making a production. And there's an agreement, a commercial document by which we say that we will pay money, he will manufacture. Thereafter, tax invoices, purchase invoices are all there. Now, after the negotiation, he writes a letter to me. So first is I give him a balance confirmation. I give him a ledger, shows the amount. In reply, he gives me a letter unconditionally accepting the liability and also says that I want to pay you off. I want to sell the factory land and then I'll pay you off with a particular period. This comes in the month of May this year. Not this year, the last year.
Still we are in this year.
Yeah, we are in January. After 15 तारीख को भी चलो. So it comes in May that I'll pay you off in 15, 21 days or 1 year month. So we say, okay. Then he sends us a balance confirmation once again, his ledger, his books, my ledger, the same figure. Now what I find that he is selling off those lands. I have annexed the deed of conveyance. We have got from other sources, we have annexed certified copies, that he is selling away the factory land and he is not paying me. He is not paying me, but selling away the factory land at Howrah, also the office at Crooked Lane of Shialda. So he's selling away. So, Calcutta Crooked Lane. Now, today, my lord, my prayer before your lordship is, first is order 38 to show cause. That has to be there for a security. Now, on the injunction prayer, my lord, I say, my lord, I have a balance of 84. 8469, which is admitted.
Suit for recovery.
Yes, suit for recovery, plaint as page 21. The prayer portion of the plaint is at page 34.
84 lakh 69,000.
84 lakhs. And now with interest, it goes up. But 84, I restrict as 84. Now, will kindly come to page 88. This is my suit for recovery. Page 88 is the straight away a document from the defendant. This is the. I will be coming up with a judgment upon admission based on this document, but till today, if he sells away the property and siphons the money, then I left with nothing for recovery.
This is of the defendant's letter?
Yes, this is defendant's letter. This is from Ashirvad, the defendant. This is 5th of 10th of May. He admits the foundry is non.
Can I go against the Ashirvad?
On me. So he admits in the first para that outstanding of 84.
So he is admitting 84.
84, yes. Balance is my interest component. And then he says, due to internal problem, we have to divert those funds and pay off the high rate of burden interest right now. To reduce interest, we have decided to sell our land and pay Axis Bank, yourself and other creditors.
Correct.
We can assure you that along with sale of this land, we will repay your entire advance against order in full, as we are unable to supply against your order. As we repay back Axis Bank through the sale of this land, we will repay your outstanding in full as well. In the meantime, we plan to repay Star Pipe, is me, within 15 days from receipt of this letter, and the repayment shall be made through the money received from the sale of the land. So he gives a timeline also how to pay. The next page, my lord, 89. 89, let's see the email. The email in the top is my internal, the one from Ashirvad to Star Pipe, the below one. This is on 28th of March 2024. So in March, he sends me a ledger. Now kindly turn to page 91, which is the continuation of the ledger. In the ledger also it's 74.
74, 69.
70, and then 10 lakhs was subsequently paid, which this is up to March.
So, page 88 is the dated 10th of May 2024.
Yes.
And this is September 20.
No,
March
this is, yes, 24. After,
March 24.
yes, this is prior to 2 months.
Before that.
Prior 2 months. So prior 2 months, it was 74. Then after it became 10 lakhs more. My ledger is at page 87, because the payment which I must show you to lordship, the 87, this 10 lakhs was paid on 9th April, which is evident at page 87. It was 74.69, the same figure on 1st April. And this is my ledger.
Yes.
9, so this 10 lakhs is not figuring in the defendant's ledger up to 31st of March. So this payment was made in 9th April 2024. So the figure is now, he admits of 84 in the letter at page 88.
Yes.
Now the difficulty is now in the volume 2. In the volume 2, my lord, I have today, he is now selling away. There are pleadings at paragraph 24 of my application and the document. is selling away this land. That this is a deed of July, Mana. Now, will kindly turn to page 107. Is Ashirvad Foundry, which is the defendant here, and he's selling this land to some Giri, whatever, and the schedule is at page 123.
Page 120.
120 the schedule, which is the Howrah land where he's having the factory. This is one conveyance.
How this court is Howrah land? How this court
No,
is having?
not on the Howrah land. I am asking the defendant. The defendant is within jurisdiction. He's selling a land in Howrah. I cannot. No. The defendant is within the jurisdiction. This is absolutely. The defendant is in Crooked Lane within Hay Street.
What is the date of this?
Yes, the date is in July. Date in July. The certified copy I obtained at page 104. My knowledge is 12th of December. This is the first document. And
104.
104 is the certified copy page, my lord. That is it. I obtained certified copy in December when I
30 July.
yes, deed of conveyance.
30 July.
30 July deed of conveyance. And there is another deed of conveyance which is page 138. This is April 2024. This a portion of the same land. There may be other deeds also, but we can lay hands only on these two, maybe unregistered documents or whatever. Is selling in plots. Now, in view of this schedule is at 154. The schedule, the same land, man.
Yes.
So today, my lord, because of this admission of
Same land means?
no, the same land means it's selling in plot. The land is a huge chunk of land where the factory was situated. Now here he's selling 4 katas. The other one was 3 katas. I'll just show you the schedule. If Lordship compares the schedule, it is page 124 and 154, the two schedule. 124 is 2 katas. Data kunta.
The tag number 977.
Data unna jum.
975. Part of 975.
Oh, there are two lands, but it must be small. Same factory sheet. Okay, on address. Whatever. I mean, he's selling away lands and I'm not asking injunction, whatever. Because the land is beyond the jurisdiction. Now, he has an office. So today.
So what is a prayer?
Yes. The prayer, my lord, prayer C. My lord, as on date, my lord, I will be pressing for prayer C. Even because other prayers, when I say that you want to sell your land, you sell your land, but it should be a special officer or whatever, that money should be secured. I am not stopping you from selling your land, but prayers C and D, that much, as on date, my lord, I can press before your lordship, and obviously prayer A and B is for show cause.
No, with regard to the D, they already sold out.
No, there are the rest of the rest of the land, because lordship will see my pleading at paragraph 25. They are selling in piecemeal.
Piecemeal. What was the total area of the property?
But paragraph 25, because I'm in business with him. I'm not that way aware of the entire land, but I know that this is the premises of 46, 47, and 48 E Road and P34 Benares Road. This I'm saying in selling in parts. Yeah. Oh, it's a huge land, that's the reason I've asked for a special officer also. That
no, the premises situated premises number 46, 47, 48 E Road.
E Road and P34/2 Benares Road.
Where is the document to that effect?
No, this is the sale deed.
No, sale deed is something else. That's why I'm telling.
No, I'll just show.
Kindly come to the 154. Kindly come to the 150.
E Road 154.
154 E Road.
E Road.
But premises 51.
No.
Correct.
I'll just tell you.
Dag you have not given the dag number.
No, page 154, the schedule is E Road.
E Road.
Premises 51, E Road.
Correct.
And page 123 is the premises P34/2, Benares Road. There are two premises.
P34/2 Benares Road.
I'm told there is one premises, but there were two addresses because of the huge chunk of land or the two address. We have received only these two deeds, my lord. 51 may be also there because I am not in.
If you come to again 123,
120.
piece and parcel of the land bear so and so square feet only out of holding number. What is the total area over there?
Total area I'm not aware. Total area.
So if today if we pass an order and it is only the land.
I know.
That's so.
No, yes. I'm not aware because I am in business with him. I'm not measuring his land. That's my predicament, my lord. I admit, my lord, in that even, my lord, then. So for prayer C is concerned, I'm able to satisfy your lordship. The prayer C is he should not operate his bank account without leaving this balance. Prayer C.
The PAN number.
PAN, because I have linked it with the PAN number. Whatever is the link is with the PAN number, but I have given a
PAN number. How you describe?
PAN number, paragraph 29. My pleadings are also paragraph 26, my lord, is diverting funds.
Yes.
Now, I know the entire land is gone, then
That is the problem.
the entire land is gone.
The plaintiff has filed this suit being CS number
Injunction to
CS form 819 of 2024. Praying for decree for a sum of rupees 84, 69, 294.13 paise along with interest at the rate of 18% per annum. Consent for the plaintiff has also filed an application being GA-Com 1 of 2024, praying for interim relief. Consent for the plaintiff submits that the plaintiff and the defendant were having business relationship since 2004 and have executed 3 memorandum of understanding dated 1st April 2004, 1st April 2007 and 7th November 2010 for purchase of cast iron manhole covers with frame and cast iron valve box / service box and various other types of rough iron casting. Police. The concept for the petitioners and plaintiff submit that
Failed and neglected.
in furtherance of such agreement, the plaintiff has paid an advance amount on various dates in the financial year 2023-24 to the tune of rupees 79,19,560.13. Full stop. The counsel for the petitioner further submits that the plaintiff has further paid an amount of rupees 10 lakhs on 9th of April 2024. It is the case of the plaintiff that even after receipt of the total amount of rupees 89,
Where is 84?
84,
84, page, para
69,
11.
294.13,
Sorry.
the defendant failed to supply the materials as agreed between the parties. Accordingly, the plaintiff has requested the defendant for return of the amount. Full stop. By a letter dated 10th of May 2024, the defendant has admitted that the factory of the foundry of the defendant is non-operational since 12th of January 2024 and has admitted that an 84, 69, 294.13 is outstanding against the plaintiff, which was provided by the plaintiff as an advance against the pending orders. Full stop. In the said letter, the defendant has further stated that due to some internal problem, the defendant has diverted those funds to pay off high interest burden, and to reduce the interest burden, the defendant had decided to sell out their land so as to enable the defendant to repay the amount to the Axis Bank, to the plaintiff as well as the other creditors. Counsel for the plaintiff submit that the defendant has also admitted with regard to the amount by a ledger for the year from 1st April 2023 to 27th of March 2024. Counsel for the plaintiff submit that in the said ledger, the due was shown as rupees 74, 69, 294.13, but subsequently on 1st April 2024,
9th April.
9th April
9th.
2024, the plaintiff has paid further amount of rupees 10 lakhs, and as such, the total amount would be rupees 84, 69, 294.13. Then counsel for the plaintiff submit that in spite of assurance given by the defendant that after selling of the landed property, the defendant will repay the said amount, but now the plaintiffs came to know that the defendant has executed a conveyance deed in favor of the third party, two conveyance deed in favor of the third party, but in spite of receipt of the said amount, the defendant has not paid the dues to the plaintiff, and the plaintiffs also came to know that the defendant is transferring the said amount to some other third party instead of paying to the plaintiff, and as such, the plaintiff has prayed for ad interim order restraining the defendant from operating their bank account, which is connected with the PAN number AA, C, A 4695A, without leaving a balance of rupees 84, 69, 290. At the landed counsel for the plaintiff peruse the materials on record. It is found from the record that the defendant, by a letter dated 10th of May 2024, has admitted the claim of the plaintiff for a sum of rupees 84, 69, 294. In the said letter, the defendant has categorically stated that the defendant is facing some difficulties, and as such, the defendant had decided to sell his landed property to repay the amount to the plaintiff as well as the Axis Bank and other creditors. Full stop. In spite of the assurance given by the defendant, the defendant now the plaintiff came to know the defendant had already executed two conveyance deeds with respect of his landed property in favor of the third party and has received huge amount. But in spite of receipt of the amount by selling his property, the defendant has not paid the said amount. On the other hand, the defendant is siphoning off the said amount to other parties. Full stop. Considering the above, this court find that the plaintiff has made out a FFC case and balance of convenience and inconvenience are in favor of the plaintiff. This court also found that the defendant has categorically admitted the claim of the claim of the plaintiff, and also admitted that he will pay the amount by selling the property. From the record, that is the two conveyance deeds which the plaintiff has relied upon, it's found that the defendant has entered into the sale agreement, entered into a conveyance deed, and has received handsome amount from selling of the said property, but the amount has not been paid to the plaintiff in spite of the assurance given by the defendant. Thus, if at this stage an ad interim order is not passed, there is every chance that the plaintiff will suffer irreparable loss and injury. Accordingly, the defendant, defendants, their man, agent, and servants are restrained from an order of ad interim injunction from operating its bank account linked with its PAN number AACC capital A 4695 capital A without leaving the balance amount of rupees 84,69,294.
Another thing, the prayer D, I have also asked for that office. If Lordship is not with me, with that regard to the factory premises, is also with one crooked lane. This is within jurisdiction. And we not create a third party interest for the time being.
Which
on
one?
this. The prayer D, the last line, the Benares Road, Lilua, Howrah, as also the office space at one crooked lane.
And
This is within the
and also restrain the defendants, their man and agent to alienate the office space situated at number 1, Crooked Lane, ground floor, Kolkata 69, West Bengal till कितना तारीख है 7 till 28th of January 2025. The plaintiff is directed to serve the copy of the plaint, application and the documents within immediately, and to file the affidavit service by the next date.
My matter is returnable on 28th.
That's a matter appear on 28th.
28th. Deeply up.
My lord, I am for the petitioner. My lord will recall in this matter, my lord, the last order of your lordship is of 13 December 2024, when your lordship was pleased to, my lord, extend the order to other bank accounts of the defendants. My lord had asked us to serve a copy of the supplementary affidavit on the defendant respondents. My lord, some have been served, but because they are, my lord, in Bangladesh, my lord, some of the service has not been able to be completed. No affidavit has also been filed because your lordship had kindly come to internal page 3 of the order.
Yes.
The lordship also gave them time to file affidavit in opposition. That has also not been filed. My lord, I was beseeching your lordship to keep this matter not in the new motion but in the adjourned motion. And my lord, I shall get those, my lord, tracking reports finally, and my lord, file that affidavit of service. I could not file it because the tracking reports are not complete because of Bangladesh, my lord, service. So kindly give me 2 weeks time, my lord, and places it in the adjourned motion, my lord.
Since appearing for the plaintiff, none appears on behalf of the defendant. Please counsel for the plaintiff submit that in terms of the order passed by this court dated 13th of December 2024, the plaintiff had sent the notice to the defendant by speed post, but It is of the Bangladesh, and
Again,
thus
order
the plaintiff has not received the track report, and thus full counsel for the plaintiff press for adjourn the press for fixing the matter after a period of 2 weeks. In view of the submission made by the counsel for the plaintiff, let the matter appear on 21st of January
Yes, but the
2025.
interim order is till 3rd January. That
20,
is today.
21st of January 2020 under the heading adjourn motion. Full stop. Counsel for the plaintiff submitted the interim order granted earlier. By which order?
My lord, that is order of 3rd December 2024.
Order interim order
Internal
granted
page
earlier
2.
Earlier is going to be expired today and paid for extension of the interim order. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till 24th of January 2025 or until further order, whichever is earlier.
But I appear for the petitioner. My lord, item 4, my lord, there are 3 GAs. My lord, I'd like to move GA4 first. GA4 is the application of defendant numbers 13 to 14 for acceptance of their written statement. My lord, with my lord's leave, we had filed it on 12th December 2024. Written statement affirmed within 120 days. 69 days is the exact delay, my lord.
Not a
4th
part and
October.
parcel of this application, Your Lordship.
No, we filed it and served, my lord, we'll serve a copy. We filed it with leave of court, my lord. And my learned senior friend was present online at the time of mentioning as well.
No, I'm not on that matter.
My lord, we'll serve it as soon as it's
pleased
accepted.
to direct that the written statement should be a part of this application.
Correct.
It's not there.
My lord,
That
that
is what I'm
was
saying.
initially
You
12th
filed in
December.
the department?
Yes, my lord, with
We have
leave
not
of
been
court.
served.
With
We
leave
have
of
not
court,
been
my lord,
served.
12
After
December.
acceptance has been passed and order.
Yes.
Where is the written statement?
My lord, it's on record. We filed in the 13 and 14 written statement recorded.
My lord, item number 4, I am appearing on behalf of defendant numbers 11 and 12, my lord, of the plaintiff.
How many defendants? Total 14.
14 defendants.
How many defendants have filed written statement?
My lord, today, my lord, we'll be moving for 4
Which for
defendants.
the plaintiff?
I'm for the
How
plaintiff.
many defendants have filed written statement? Nobody.
No. Till date, we
No,
have not received
My lord,
anything. But
these
Your Lordship,
applications have come up today for that purpose.
As per
We'll serve
the
everything.
service report, everybody has been served. Your Lordship.
Served.
Less.
So where is your application?
My lord, application is GA4, my lord.
GA4. When you receive the written this
Date of summons is
date of
4th
summons?
October 2024. Thereafter, my lord, the puja holidays started,
Just
my
a
lord.
minute. 4th October.
4th October 2024. My lord, we'll
Correct.
find that.
And when you
My lord,
from the written statement?
12 December 2024.
12th December.
Yes. That is 69 days.
69 days.
Yes. So, my lord, 69 days delay, and my lord will kindly appreciate the plaintiff is 168 paragraphs. It took time, my lord. That is the real reason. My lord, we took time to, my lord, even to dictate the written statement will take substantial time.
Why?
My lord, I've explained that, my lord.
What you are doing? What you are doing in the
No
weekend?
explanation.
No, my lord, explanation is there.
There is
My lord,
explanation.
my lord, we kindly take paragraph 3 onwards. Paragraph 3 onwards, my lord, we engaged advocates. There had to be several conferences, my lord, to dictate the written statement and to prepare it. The
No
documents relating. No.
No date, nothing, Your Lordship. Lordship will see anything.
69 days delay, my lord, I don't.
69 delays, no day-to-day declaration that what is the delay, why it is, no nothing. The delay has to be dealt with day by day, Your Lordship. It has to be declared, Your Lordship. Nothing, no date, single date is not there, Your Lordship. From 4th of October till the date of filing, no single date is not there.
The plaint is 168 paragraphs and thereafter 4 volumes.
Right?
I've stated that.
Yes, only one application. Any other
No,
defendants?
yes, my lord, I also appear for defendant number 6 and 7. My lord, that is GA5 and 6. 6 and 7, my lord, I have also there, my lord, the written statement is annexed. That has not yet been filed in the department, my lord. We're carrying the originals. GA5 and 6. GA5 and 6. That is defendant 6 and 7, my lord. There, my lord, the written statement is annexed to the applications, my lord. Rate of summons received on 30th September 2024. Affirmed, my lord, on 19th December 2024, my lord.
But we are not filed.
We've not filed it, but we're carrying it in original, my lord. My lord, will grant me leave, we'll file it, my lord, in the
No,
department.
it could have been filed within 120 filing.
It's within 120 days, my lord. 120 days expires on 28th January 2025. 28th January 2025. I'm carrying it in court, my lord. Can take it on record.
It's affirmed.
It's affirmed. Affirmed on 19th December, my lord. Before the oath commission.
Absurd.
It's part of the application, my lord. The affirmed written statement is a part of the application.
Let me see first.
Yes.
Yes. Yes, what is your objection?
My lord, with regard to defendant number 1, 2, 4, and 5, my lord, written statement is being drafted, but it's not being filed. I'm praying leave to file within.
No, these are commercial. Leave nothing. If you file within 20 days, come with that. If not,
Within 120 days, will, as my learned friend has said, it's will.
okay, you come.
Lordship.
Come with a written statement. You
Lordship.
draft, you affirm, and come. Then we'll see. Yes.
Lordship, grateful.
So appearing for the plaintiff. So you are appearing for the 1 to 5.
1, 2, 4, and 5.
1,
1, 2, 3, and 5, my lord.
1, 2, 3, and 5. So appearing for the. You are appearing for the.
Well, 13 and 14 for GA4 and 6 and 7 for GA5 and 6.
7, 13, and 14. 6, 7, 13, and 14. And
But in 6 and 7, Lordship will see what the
let
explanation
me
they
see.
have
Let
given.
me, yes. Another. Nobody.
My lord, defendant numbers 11 and 12, my lord.
What is your application? You have filed a written statement? No.
My lord, we are in the process of filing an application.
So for the 11.
Process. Active.
The defendant number 13 and 14 have filed an application being GA 4 of 2024, praying for extension of time to file written statement. Counsel for the defendant number 13 and 14 submitted. The defendants have received the writ of summons on 4th of October 2024. But the written statement could not be filed within 30 days. But have filed the written statement on 69th day by affirming the same, and it is already filed in the department. Counsel for the defendant number 13 and 14 submits that after receipt of the writ of summons, the same was duly forwarded to the office of the defendant number 13 and to the learned advocate for taking appropriate steps. And as per the instruction of the learned advocate, the defendant number 13 and 14 have started searching their documents as per the advice of the learned advocate for preparing the written statement. And in the meantime, there was a puja vacation, due to which the written statement could not be filed. Full stop. And learned counsel for the plaintiff raised objection and submitted that no proper cause has been shown as to why the defendant number 13 and 14 have not filed their written statement within the prescribed time of 30 days. He submitted that no date has been mentioned when they have advised to the learned advocate and when they have got all the documents and have been handed over to the learned advocate. He prays for dismissal of the rejection of the present application. Had the learned counsel for the respective parties produced the application, this court find that the defendant number 13 and 14 have received their writ of summons on 4th of October 2024 and have affirmed the affidavit, affirmed the written statement on
12 December
12th
2024.
of December 2024. That is though after the period of 30 days, but within the period of outer time of 120 days. This court find that the defendant number 13 and 14 has shown a sufficient cause why the written statement has not been filed within the prescribed period of 30 days. Full stop. Considering the above, this court is of the view one opportunity should be given to the defendant number 13 and 14 to file the written statement, but subject to payment of cost of rupees 5,000 to the plaintiff. Full stop. Counsel for as the written statement is already filed in the department is directed to accept the written statement subject to scrutiny by the department. Full stop. The defendant number 13 and 14 are directed to serve the copy of the written statement to the learned counsel for the plaintiff in course of the day. GA number is disposed.
My lord, could I pray, my lord, for some reduction in the cost? I know, my lord, as per Act, my lord has to impose cost, but my lord, 5,000, my lord, my client is not at fault.
There are 14.
My lord, my application under
Lordship,
section
there is a
45 still pending.
Lordship, there is a counter claim.
No, not in 13. No.
Oh,
In
yeah,
13,
yeah.
14,
6
nothing.
and 7,
My lord, no
Lordship,
counter claim, my lord, we kindly consider.
6 and 7
Another?
counter claim.
GA
Well,
number?
GA 5 and 6, my lord.
Lordship will see the GA number 5. After the paragraph number 4, Lordship will see the explanation. From third, Your Lordship, they are saying on 30th September they received it. They filed the written statement. Lordship, now Lordship will see the 5, voluminous and others, nothing.
My
0.
lord, also, my lord, the defendant number 6, my lord, personnel were not present, my lord. That was a difficulty, my lord. It's a public
So you
limited
filed the
company.
You filed the counterclaim also?
In
Yes.
GA 5, that is for defendant number 6 has filed a counterclaim, yes, my lord. My lord, we pay the court fees, my lord, as per the rules. For 7, my lord, there is no counterclaim. For defendant number 7, there is no counterclaim.
You have filed about 5, 6?
5 and 6.
5 and
GA
6.
5 and 6. One for defendant number 6, one for defendant number
Both,
7.
when they are received?
My lord, 30th September. Both received on the same day, 30th September 2024.
And both have filed the counterclaim?
No, only defendant number 6 has filed a counterclaim.
Defendant number 6 of the GA number?
That is GA number 5, my lord, should be. GA number 5.
Yes.
Yes. And defendant number 7 has not filed any counterclaim. He's filed written statement.
So and so opening for the plaintiffs. And that already hai. The defendant number 6 has filed an application being GA Com 5 of 2025. So praying for extension of time to file written statement along with counterclaim. The defendant number 7 has filed an application being GA Com 6 of 2025, praying for extension of time to file written statement. Full stop. Counsel for the defendant number 6 and 7 submits that the defendants have received the writ of summons on
30th September
30
2024.
September 2024. After receipt of the writ of summons, the defendants tried to collect all the documents, due to which and all the documents for preparation of the written statement, due to which the defendants could not file the written statement within the prescribed period of 30 days. But counsel for the defendant submit that, and defendant number 5, 6 and 7 submit that though that they have not filed the written statement within a period of 30 days, but have affirmed the written statement and enclosed the copy of the written statement along with this application on 19th of December 2024. He submits that the written statement has been affirmed and disclosed in the present application. Within the period of 120 days. Full stop. Counsel for the plaintiff raised objection and submitted that the defendants have received the writ of summons on 30th September 2024, but have not made and not shown any cause as to why the defendants have not filed the written statement within the prescribed period of 30 days. Counsel for the defendants submit that as the defendants have not shown any sufficient cause, and as such the application is liable to be rejected. At the learned counsel for the respective parties, this court find that though the defendant number 6 and 7 have received the writ of summons on 30th September 2024, but have not filed the written statement within the prescribed period of 30 days, but have affirmed the written statement and filed and have disclosed as a written statement in the present application within the period of 120 days. Thus, this court is of the view.
Did you make an attempt to file it before the
Due
department?
to
No, cannot be.
to give an opportunity. One opportunity should be given to the defendant to file written statement but subject to payment of cost of rupees 5,000 each. Full stop. The defendant is direct. The defendant number 5 and 6 and 7 are given liberty to file the written statement in the department in course of the day.
In course of the
Yes,
In
absolutely.
course of the day.
Or my lord, kindly make it Monday by Monday.
By Monday.
To
By
be on the
Monday,
safe side.
after serving the copy to the learned counsel for the plaintiff, subject to scrutiny by the GA number.
Or the other sheet has to be there.
वो तो already department में है, उसमें force है.
My lord, there is one more practical difficulty which Mr. Upadhyay points out. I have also been told by my advocate on record that unless this order of your lordships come, the department for some strange reason
I'll tell you, Lordship, the practical
No,
difficulty in other matters.
give it my my court officer.
Yes.
My
Yeah,
court
no,
officer will
yeah.
allow.
No, my lord, one more thing. Just on a general context, my lord, in the event a party is out of time beyond 30 days, say I am on the 31st day or on the 32nd day, the department should ideally accept it subject to court giving the leave, but the department is not accepting written statement.
That's why I'm telling that I know from the since for the last 2-3 months.
Correct.
That's why I requested all the London members of the bar.
Yes.
If anybody wanted to file the return statement after the 30th days, but
Correct.
within the 120 days,
Right,
please
my lord.
come this court. I will grant the leave in the return statement itself,
Yeah.
so it can be filed subject to outcome of the.
Yes, subject to if you file an application, if that
Application
delay is
even-
not correct.
Even the law doesn't provide the application,
Right.
but our original set rules provide for the master summon.
Correct.
That is, we are not going into that controversy.
Very well.
So that's why I requested all the bar members. If anybody wanted to file the written statement, come and take
mention the matter, take the leave, and then file it.
file. Because otherwise there will be a
Correct.
conflict.
Correct.
They are telling that I am not accepting. You persons are coming here. They are not accepting. There will be some problem.
Very well. Great.
It is fine that the defendant number 6 has also filed the written has also filed the counterclaim. Accordingly, the plaintiff has the liberty to file additional written statement to the counterclaim within 30 days after receipt of the written statement.
So we'll get back our 5,000 from there.
Oh, no. You are already working on that. You are already working on that.
Grateful, my lord.
Grateful, my lord.
Subject to scrutiny. Subject to scrutiny. No, leave written statement is accepted subject to scrutiny, and the plaintiff is given liberty to file by Monday. Yes, next.
I am appearing on behalf of the plaintiff petitioner, Your Lordship. Your Lordship, one of the first application is in the nature of Order 38 Rule 5 along with other injunctions, where I am enjoying an injunction on the bank account, Your Lordship, of the amount. The second is a Section 340 application under CRPC, because in the affidavit in opposition in the former application, they have come up, the defendant came up with a document which we are saying it's forged and fabricated. And the third application, Your Lordship, is the judgment on admission, Your Lordship. Now, the judgment, after we have filed this application, Your Lordship was pleased to direct them to file an affidavit in opposition, which they failed. Your Lordship, on the
So now what you want?
Your Lordship, only the hearing of the judgment on admission is left. Your Lordship,
Whether writ of summons was served?
Yes, it was served, Your Lordship. The mode of service is part of this application only.
When it is
Your
served?
Lordship. Mode of service বলেছি, এটা আপনি কি জমা দিয়েছেন এটাতে? এখানে দেওয়ার ছিল। Your Lordship, it was served on 18th of October 2022. May I hand up a copy of this? আপনি ভুল দিয়েছেন। And Your Lordship, no written statement has been filed.
Sole defendant?
Yes, Your Lordship.
One defendant?
Yes, Your Lordship.
Original writ of summons along with the copy of censure writ of summons instead of my translation. Yes, then?
Now, no written statement has been filed.
Defendants have entered appearance through the so on 3rd of January.
Yes, the defendant has entered appearance, but no written statement has
Where
been
is
filed.
that report? Written statement is not filed. Have you obtained
Your
report?
Lordship, that report is not with us.
Obtain that.
Very well.
Come.
Very well. I'll do that.
Take this original. Bring
Yes,
all the report together so I can dispose of all this thing.
Grateful, Your Lordship.
So appearing for the plaintiff. None appears on behalf of the defendant. Counsel for the plaintiff submit that. Even after receipt of the writ of summons, none. The writ of summons was duly served upon the defendant, and the London advocate has entered appearance but no written statement has been filed. Though it is the contention of the Land Council for the plaintiff that no written statement is filed, but the plaintiff has not filed any report to show that the no written statement is filed by the defendant. Accordingly, counsel for the plaintiff prays for time to obtain report from the department to ascertain whether the defendant has filed written statement. In view of the above, the case is adjourned. Let the matter appear on how soon? 24th. By 24th.
Very well, your lordship.
24th January. Next.
IPF for the plaintiff, my lord. This matter, my lordship, had
Sure, and
already
for the
kept on 28th of January. GA3 and 4, my lord, is an order of 17 December. And I don't know why it's appearing because there are already directions for affidavit in GA4.
Let the matter appear on 2nd January. None appears on behalf of the plaintiff for the
This is my application for rejection of plaint. And
right.
yes,
Yes, my lord, there
But
is
this is
already
not
a
appealing
direction
to
for.
By which order?
So it's 17 December to 24, my lord.
lordship,
17 December.
Yes, my lord. Lord, may I hand over the order? It would mean.
lordship, this is a different GA that is appearing today. GA3 is appearing as per
This is GA3.
Yes, my lord. At
This
the,
is GA4.
at the
It was
bottom, my lord, lordship will see, my lord,
directed
of
to
that
appeal.
order. GA3 is also supposed to appear on 28th December,
Okay.
January. Lord, may I file my, my lord, affidavit in reply in GA3, my lord? It was pending, my lord. Service file? So they have been served.
GA3 filed by you.
GS3 has been
GA3
filed
is
by
our
the-
application.
What is your you are
That
for
is
the
for judgment upon admission.
you are for the plaintiff.
Yes, ma'am.
And what
I'm
is
for
your
the
application?
defendant. My application is for rejection of plaint, which they are also they have to file their affidavits.
Yes.
711.
Yes.
So and so appearing for the plaintiff, so and so appearing for the defendants. Plaintiff has filed an application being GA 3 of 2024, praying for judgment upon admission.
Yes.
Praying for judgment upon admission. So the defendant has filed an application being GA 4 of 2024, praying for rejection of plaint. Full stop. Counsel for the plaintiff, what you have filed? Reply.
Reply, my lord. In GA3.
Counsel for the plaintiff has filed affidavit in reply in connection with GA3 of 2024. Let the same be kept with the record. So it is fine from the record by an order dated 17th of December 2024 in GA.com 4 of 2024. This court has already passed an order directing the matter to appear on 28 January 2025. Let GA.com 3 of 2024 along with GA4 of 2024 4 of 2024 be appear along with CS.com 450 of 2024 be appeared before this court on 28th of January.
Grateful.
I'm great. Yes, nobody. None appears on behalf of either of the parties. No accommodation is sought for. Let the matter appear in the warning list. Next.
Your Lordship, I appear for the petitioner. In terms of your Lordship's last direction on 8th of November, your Lordship, you have obtained a report from the registry with respect to defendant number 1. No written statement has been filed. Your Lordship, I'll take leave of.
Yes.
Your Lordship, the report says that no written statement has been filed. Your Lordship, the summons was served to the defendant in 2022 by the department. And irrespective, Your Lordship, on the last occasion, we had placed an affidavit of service by which on 7th February 2024, once again, we had served the plaint to the defendant number 1. Your Lordship, 120 days since both the dates have expired and no written statement has been filed, though they have entered appearance, Your Lordship. We have a report recording their entered appearance also, Your Lordship. Your Lordship,
What about the other defendant?
Your Lordship, may I kindly take leave? My senior is.
Why you are not submitting?
Your Lordship, I can continue. That's all right. Your Lordship, with respect to the other defendant, Your Lordship, if I may kindly point out if Your Lordship may kindly have the order dated 6th of September 2023, Your Lordship.
What is the order?
Your Lordship, by the order dated 6 September 2023, we were directed to serve a copy of the plaint to the defendant number 2, which is the added respondent. Your Lordship, GA7, which is a recall application. Your Lordship, by GA4, defendant number 2 was added by the Honorable Court with its order dated 21st November. Against that order, we had filed a GA7. And considering that our GA7 was still pending, Your Lordship, with a order dated 6th of September, had directed us to serve. And Your Lordship, on the last occasion, we had placed an affidavit of service by which on 7th February 2024, we had served them a copy of the amended plaint. Your Lordship, even otherwise, we had handed them over a copy of the plaint before 7th February also, but irrespective, we had served them on 7th February also, Your Lordship. If Your Lordship may kindly have the affidavit of service that we had filed on the last occasion, I can give a copy, Your Lordship.
So whether this, what about the defendant number 2 and 3 notice served?
3 to, Your Lordship, 3 is a performer respondent, Your Lordship.
3 is the performer.
Your Lordship.
Notice is to be served.
Your
What
Lordship.
about the 2 who has been added? Regal container.
Your Lordship.
My lord, so far as 2 is concerned, my lord, 7th, there is a letter by which we have served, my lord, copy of the amended plaint. Why, my lord, we did not take steps, my lord, in the department to have the summons issued is because of the pendency of GA7, which is my recall application. My lord, seeking recall of the order by which added defendant was added in the suit. So, my lord, but court, my lord, Justice Mukherjee then, my lord, was deciding this application. My lord, Justice Mukherjee felt we should in any event serve. So, we served a copy of the amended plaint, which is recorded in that letter, which my lord, my learned junior was pointing out from the affidavit of service. So, D1 is served, D2 added defendant is served, 120 days having expired, my lord, no written statement on record. I was humbly praying if, my lord, the suit can be, my lord, declared to proceed ex parte against the defendant and the added defendant, subject to, my lord, result of the application being GA7. And the other defendant, my lord, Nepal Shipping, becomes really the, my lord, pro forma defendant against whom there is no relief. So, my lord, I am not seeking any direction so far as that defendant is concerned. Even if he files a written statement or doesn't file, does not really alter my situation.
But anyhow, where is this affidavit? This is affidavit service. But you
My
have
lord,
the advocate on record.
Yes, there will be a letter of 7th of February, page 4. My lord, kindly comes to page 4, my lord.
Page 4.
My lord, kindly sees the first advocate is the advocate for Regal Container, who is, my lord, the added defendant. The second advocate is, my lord, River Edge, which is, my lord, original defendant number 1.
How you can come to them, whether they have appeared?
Now, my lord, I have a, my lord, service report.
No, they filed the wakalatnama. Advocate on record, you are served to the advocate on
my lord,
record.
the report says defendant number 1 has entered appearance.
Correct, that's why.
And my lord, so far as the advocate for the added defendant is concerned, he was representing, my lord, the added defendant in the interlocutory application which was filed by my client, plaintiff, GA1. So, my lord, court felt that I should serve him. And so, my lord, we served him. My lord, this issue becomes academic if finally lordship, while deciding GA7, holds that no addition of this party as an added defendant. GA7 is, my lord, they had, my lord, been served. They had appeared also.
GA7 is appearing today.
Well, today it's appearing under the heading suit. Lordship can keep GA7, my lord.
That's why GA7 is to be heard.
Yes, but so far as D1 is concerned, my lord, he cannot have any further right, my lord, to contest the
D1 is okay. But
D1.
with regard to the added defendant,
yes,
because added defendant, you have served the notice to the advocate on record.
Yes,
because of the
interlocutory application remaining pending.
Interlocutory application is to be taken up for hearing.
Yes.
You filed an application for deletion of the name.
Very well.
Or
My lord, if
recording
lordship
of
wants to, my lord, deal with added defendant separately after disposing of GA7, my lord, I am fine with that as well.
That will be better.
Very well, my lord. I am okay with that, my lord. We can have that adjudicated, my lord, any day, my lord, convenient to the court.
But
Lordship may
that
fix.
J7 was served upon him.
Yes, yes. They appeared, my lord. They appeared in GA7.
Where is the affidavit?
Affidavit of service. There's an order recording their presence. My lord, gives me 1 minute, my lord. I'll just pull out that order, my lord. When we moved GA7, my lord. Justice Mukherjee's order. September 23.
Yes. February 7.
2024. Yes.
7 February. 10 February, argument on behalf of the plaintiff in support of the application
Being GA7 has commenced. My lord,
but-
kindly sees the names of the advocate. My lord, here, my lord, last name Debraj De, advocate for defendant number 2. So added defendant was described as defendant number 2 and pro forma defendant was described as defendant number 3. In the order, my lord, of 7th of February.
Regal container.
That's right, my lord. Regal is, my lord, the added defendant. So I was praying only this, my lord. So far as D1 is concerned, lordship may close their right, declare it ex parte against D1.
I am fixing undependent against the defendant number 1.
Very well,
And
my
with
lord.
regard to the defendant, added defendant, I am fixing the application for hearing GA7. You inform the next date of hearing to them. If they will come, otherwise the application will be taken up.
Grateful.
So appearing for the plaintiff. None appears on behalf of the defendants. Full stop. Counsel for the plaintiff has handed over the service report, wherein it reveals that a writ of summons was duly served upon the defendant number 1. And the defendant number 1 has entered appearance on 22nd of November 2021. But as per the 2021. But as per the report of the Deputy Registrar Legal dated 2/12/2024, no written statement has been filed by the defendant number 1. In view of the above.
My lord, one additional, my lord, I'm sorry for the interjection, my lord. The letter which we pointed out, as abundant caution, we again served their advocate. From there also 120 days is over. Very. Because they might come and contend that the amended plaint was not served.
You will that
Very
will take. No, full stop. Counsel for the plaintiff also pointed out that subsequently this court has added the defendant number 2, and after the addition of the defendant number 2, the plaintiff has served the amended copy of the return of the plaint to the defendant number 1 through the notice dated
7th February 2024.
To the notice dated 7th of February 2024. But in spite of receipt of the said notice, no written statement is filed. Full stop. Considering the above, this court find that time to file written statement, and this court find that the suit filed by the plaintiff is commercial in nature, and time to file the written statement is only up to 120 days. That is the outer time of filing written statement, but the defendant number choose not to file the written statement. Accordingly, CS Com 314 of 2024 within bracket old CS 192 of 2024 be placed in the list of undefendant against the defendant number 1.
It should be defendant number 1. Last
against
line.
the defendant number 1.
Yes. No, their lordship, I think, dictated D2, my lord, penultimate sentence.
Full stop. As regard the defendant number 2, the plaintiff has shown the service of notice upon the defendant number 2, but none appears on behalf of the defendant number 2. Counsel for the plaintiff submit that the plaintiff has also filed an application being GS7 of 2023, praying for recalling of the order wherein the defendant number 2 has been added as defendant in the present suit. The In spite of full stop, in spite of receipt of the notice, comma, the defendant number 2 has not appeared. Full stop. This court find that before passing any order for filing written statement by the defendant number 2, it would be proper to dispose of the application being GS7 of 2023 filed by the plaintiff, wherein the plaintiff has prayed for recalling of the order wherein the defendant number 2 has been added as a party. Let the matter appear on 27th of January 2025 under the heading new motion, under the heading adjourn motion for hearing of GS7 of 2023.
Grateful, my lord.
The plaintiff is directed to inform the next date of hearing the learned counsel for the added defendant number 2. It is made and to file affidavit of service. It is made clear that on the date fixed, if the defendant number 2, in spite of receipt of the notice, failed to appear before this court, comma, this court will proceed the hearing of GS7 in the absence of the defendant number 2.
Grateful, my
lord. Lord, item number 9, I appear for the plaintiff, my lord. My lord, there's an application, my lord, appearing for the first time today. My lord, an application
What's the application?
my lord, judgment upon admission. My lord, may I
Who is for the defendant?
My lord, the defendant hasn't been appearing. If I may just indicate, my lord, suit for goods sold and delivered, price not paid, my lord. My lord, they have not entered appearance. My lord, pursuant to which there was a direction by Justice Mukherjee that the department is to see if it's to be placed in the undefended list. My lord, that was by an order dated 23rd of February 2023, my lord. My lord, now we filed an application, my lord. My lord, no written statement filed. They have not entered appearance. To my instructions are that it hasn't happened. My lord, the writ of summons has been served. The bailiff's report, everything is there, my lord. There is also a certificate from the department that they have not entered appearance. My lord, today the application before my lord is a judgment upon admission, my lord, based on an admission, written admission by them to the effect that they owe us the money which we've claimed in the suit. My lord, we have, as a measure of abundant caution, although it is essentially an undefended suit, proceeded to serve the defendant. My lord, what we have, my instructions are that it has come back as undelivered because it shows it is insufficient address provided. My lord, so far as the interlocutory application is concerned, my lord, I have myself seen, my lord, the address mentioned in the letter and the address in the plaint as well as what was served by the bailiff, they all match. My lord, I was praying today, my lord, if you can be permitted to try and serve again and come back, my lord. My lord, because this is essentially...
Why you are going for the order 12 rule? When they are not appearing before the court, notice was served, come with the undefended suit, bring the evidence, close the case.
My lord,
why you are taking the risk of the order 12 rule 6?
My lord, may I indicate, my lord? My lord, there is a categoric written admission on the...
Correct. See, categorical written statement if suppose the defendant is appearing.
My lord.
Now the defendant is not appearing.
My lord.
Correct.
My lord.
As per you have a sufficient documentary proof of the office report that the writ of summons has been served, no written statement is filed. And it is only sole defendant.
My lord.
Correct. So, and you wanted the decree
My
from
lord.
this court,
My lord.
either this way or that way.
My lord.
Order 12 rule 6 on the basis of the admission.
My lord.
That is your chance. We don't know whether what the court will accept your admission or not.
My lord.
But you have a good chance in the undefended suit. You proceed with the undefended suit.
My lord, may I indicate, my lord, perhaps, my lord, I follow what has fallen from my lord, my lord.
No,
my
if
lord,
you want, the court only.
my lord, I follow, my lord. My lord, we were only thinking that from the perspective, it would speed things up from the perspective that if we succeed here, we are able to obtain a degree. If not, we prove it by evidence, my lord. That is the, my lord, if I may be so candid enough to state that, my lord.
Since appearing for the plaintiff, none appears on behalf of the defendant. Also, counsel for the plaintiff submit that. Writ of summons was writ of summons. Is there any order with regard to the undefended suit?
My lord, there was an order by.
Yes, kindly come to the order.
My lord,
11 November.
My lord would kindly see also, my lord. My lord would take 11 November.
11 November order, kindly see. 3rd December witness action.
My lord would kindly see the 23rd February order. My lord, what perhaps my lord is looking for is 23rd February 2023 of Justice Mukherjee.
Defendant has not entered appearance for 14. Produce the code. So 120 days of the service of return and long back. Defendant has not taken any application for extension of time. Considering someone keeping in mind under the procedure doesn't defendant. Warning list to be transferred to the then
My lord,
correct. After that, this court has passed an order.
my lord had passed an order
Ah.
on the 11th of November that
11
witness
November.
action is to commence, my lord, which is why, my lord, we say, my lord, it is there, my lord. We are taking an attempt to see if it could be shortened, my lord. The witness action and everything, if there is a categoric written admission, if we could succeed on that. And my lord, before, if I could just place the affidavit of service, it shows, my lord, it has been returned with the, and the address matches with the writ of summons, my lord.
It is fine from the record. It is so suffering for the print, none appears on behalf of the defendant. It is fine from the record by an order dated 11th of November 2024. This court has placed the matter in the list of undefendant suit and has fixed in the undefendant suit and also fixed the matter for witness action. Today, when the matter is taken up for hearing, the learned counsel for the plaintiff submitted the plaintiff has filed an application being GA Com 2 of 2024, praying for judgment upon admission. He submitted that the application was also duly served upon the defendant, but it was written unserved on the with the endorsement address is insufficient. Counsel for the plaintiff submit that the address in which the plaintiff had sent the application to the defendant is the same address appearing in the cause title of the plaint and the writ of summons which was served upon the defendant. But in spite of the same, there is a report that address is insufficient. Accordingly, he prays for leave to send the notice of GA Form 2 of 2024 again to the defendant. In view of the submission made by the counsel for the plaintiff is granted leave to serve the copy of GA 2 of 2024 within a period of 1 week from date. 1 week from date, and to file affidavit service on the next date fixed. List the matter on 28th of January 22.
Grateful, my lord.
My lord, I am appealing for the plaintiff. The plaintiff has filed this suit for a claim of rupees 2 crore and 71 lakhs and odd. And after adjustment of all the dues of the bank. However, in the meantime, while the matter was sub judice, this account has been assigned to a asset reconstruction company, which we have objected to, and
no, but GA5.
GA5 is not appearing, my lord.
GA5 is not in the department also. There's a report. No GA being numbered 5 of 20 yes, yet been filed and registered in the department.
My lord, last occasion when I mentioned it before your lordship.
This court has called for the report.
My lord.
And the report has come, the no GA is filed.
But my lord, my person has gone. There was some defect, which again has been rectified, my lord, and it is there in the department. And today also he went, but the person concerned who was dealing with the file, he is not there. हाँ बोल रहा कि नहीं है डिपार्टमेंट में ऐसा रिपोर्ट देखो जाके.
No GA.
My lord, I will send my person again, but my lord, let there be an order for appearance of GA5, my lord, in the
No, I can, but report is with me.
My lord, my lord.
So if you pursue with the department, if it is there, come and mention, then I will pass an order for bringing the record. Because after this order, I cannot pass an order.
My lord, my lord, I understand. I follow your lordship, my lord.
So what do you want now? So I am simply adjourning the matter.
Let the matter be adjourned. In the meantime, my person will inquire with the department, and it will be mentioned, my lord.
So and so appearing for the plaintiff. Now, none appears on behalf of the defendant. The registrar original side has filed the report dated 20 November 2024, wherein it is mentioned that no GA being numbered 5 of 2024 has yet been filed and registered in 5 of 2024 has yet been filed and registered in the department. Will counsel for the plaintiff submit that the plaintiff will take appropriate steps to ascertain whether the GA is filed or not. In view of the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 21st of January.
My lord.
Next.
My lord, I am for the plaintiff, my lord. Yes. My lord, defendant in this matter, my lord, didn't appear on the last occasions, my lord. My lord, only thing, my lord, that my lord, as I had pointed out, my lord, the erstwhile advocate on record of the plaintiff, my lord, in two matters that actually happened, and one matter lordship directed us to directly file in the department, and this is the another matter. My lord, we had to immediately mention when the last order was passed on November 22 that about the typographical error that we didn't. My lord, kindly see, my lord, this should be the I've tried to input the correction. Actually, it should be no objection has been given by the defendant, by the plaintiff's advocate, erstwhile advocate. It had been gone as no objection. So, my lord, that is the today. If your lordship, my lord, without going into, yes, ma'am, without going into all these things, my lord, kindly direct me to file the leave to file the vakalatnama in the department. That will serve the point. Rest will accordingly proceed, my lord.
So suffering for the plaintiff.
Even without Janan Joseph, without
And appears on behalf of the defendant. Counsel for the plaintiff submitted. The erstwhile advocate who is advocate on record who is appearing for the plaintiff is not providing no objection to file a fresh vakalatnama by the present advocate on record, due to which the present advocate on record is not in a position to file vakalatnama
in the department.
Vakalatnama in the present case. Considering the above, the leave is granted to the present advocate on record to file vakalatnama without any objection from the erstwhile advocate on record within a week from date.
Grateful. Yes. I'm deeply
My lord, item number 12, I'm appearing on behalf of the plaintiff, my lord. Learned counsel is appearing physically.
I'm appearing for the defendant in this matter. But I appear for the plaintiff. But here, Lordship will see Lordship's large order. But the defendant's application for stay of my suit was heard by the previous bench.
What is that?
Was
Reserved for judgment. So they stop.
No, there's no order, but practically it is.
Practically stop.
Practically it is. We have mentioned.
So as like we file the revision and call for the lower court record, automatically
and the suit is
stayed.
stayed. Lordship will give us some time, but we have mentioned the matter. But
So appearing for the plaintiff, so appearing for the defendant. As per the prayer made by the counsel for the respective parties, the case is adjourned. Let the matter appear on 7th of February 2025.
much of it. Hopefully by then.
Grateful, my lord.
Grateful.
Your Lordship, I'm appearing on behalf of the plaintiff. On the last occasion, we had indicated that the plaintiff number 3 has passed away. Since the plaintiffs here have filed the instance suit in the capacity of trustees, a reconstitution deed has been made by the plaintiffs that may kindly be taken up on record, and we may kindly be allowed a week's time to take further necessary steps in the matter.
Why? What purpose it is by keeping this on record? And in terms of this deed, you take appropriate step by bringing all these events on record.
Yes, absolutely. Your Lordship, kindly grant us a week's time to take necessary steps.
As per so appearing for the plaintiff, full stop. As per the prayer made by the counsel for the plaintiff, the case adjourned. Let the matter appear on 31st of January.
Grateful to your Lordship.
So I'm appearing for the plaintiffs, your Lordship.
I'm appearing for the defendant number 1, my lord.
Yes.
For interim reliefs, your Lordship. Application was filed and disposed. The interim order was confirmed till disposal, your Lordship. Application was also filed for extension of time to lodge summons, Lordship. Writ of summons has been lodged.
Lordship kindly calls for a report for the upon status of service.
You are appearing for?
Oh,
So the plaintiffs, Lordship.
I'll just indicate defendant number 1 is the party which is within the jurisdiction. So far as defendant number 2 is concerned, it's based out of Afghanistan. So that is why number of attempts were made by them. They could not serve. Service could not be effected. And thereafter, my lord, I took out an application for extension of time to file my written statement. That was disallowed because it's a commercial suit. My GA was dismissed. I wish to contest in the manner that I understand that I do have a right to cross-examine. So only limited to that, I would like to participate in the proceeding. Rest, the necessary formalities may be complied with.
So pro forma, Your Lordship, summons service is not confirmed, Your Lordship.
That multiple attempts were made by them. It's not possible because of political reasons right now.
So why you are not taking a step through the embassy? Through the embassy, Indian embassy to
Everything was done as far as I.
Indian embassy, that was another suit, ma'am.
Okay. Okay.
Birth tabs.
Okay.
take steps to the Indian embassy. There's a procedure on
Because there is a same matter where they have done that. It is also appearing today in the list.
It was also tried, Your Lordship. There was no response from the embassy. Afghanistan embassy in New Delhi and Indian embassy in Afghanistan, Your Lordship. Another suit. This is another one. Here also this is Afghanistan party, Your Lordship.
So what do you want now?
In a week's time, Lordship, I'll come back with service report, Your Lordship, from the sheriff. Summons were lodged, Lordship.
So appearing for the plaintiff, so appearing for the defendant number 1. Counsel for the plaintiff prays for a week time to obtain report from the sheriff. In view of the submission made by the counsel for the defendant, report of the service, report from this sheriff with regard to service of notice upon the defendant number 2. In view of the submission made by the counsel for the plaintiff, the case adjourned. Let the matter appear on 24th January.
Your Lordship, I'm for the respondent in this matter.
Yes.
For the plaintiff in this matter.
How your case is contesting?
Your Lordship.
This is the first case you have contested.
There are so many other cases you will find me, Lord. Also.
Your Lordship, I want to hand over a copy of the order dated
NCLT.
NCLT, Your Lordship.
Yes.
Section 7 has already been
Moratorium.
Yes.
Where is the order?
Here is
Have
the
you
order.
copy?
Yes, I have a copy. Lordship, here's the copy. And Your Lordship, this is the last order copy. The matter has been fixed on 23rd of January 2025.
So what do you want? Last chance is given to London appearing for the respondent 1 to file reply within 2 weeks. Leave the matter 23rd January. Yes, IRP has been appointed.
IRP appointed, we'll let us see what happens on the 23rd. Can you fix any day after 23rd, Milo?
So appearing for the plaintiff. So appearing for the defendant. Counsel for the defendant submit that the matter is pending before the NCLT and is fixed on 23rd of January 2025. Counsel for the plaintiff prays for time to take instruction. In view of the submission made by the counsel for the plaintiff, the case adjourned. Let the matter appear on 11th February.
I'm grateful, Your Lordship.
Next. None appears on behalf of either of the parties. No accommodation is sought for. Let the matter place in the warning list. Next.
My lord, I am for the plaintiff. My lord, it's my application for restoration. My lord,
I am for the
22nd
respondent.
November 2024, my lord. As my lord, we could not appear before your lordship, my lord. The matter was called on and dismissed for default. My lord, it is on the said date only, my lord. The defendant has appeared. But at least 7 notices have been given pursuant to the direction of this honorable court, my lord, by your lordship as well as Honorable Justice Arindam Mukherjee. The defendant chose not to appear. My lord, my suit, my lord, in the written statement, they've admitted their claim. My claim, my lord. Everything has been admitted, my lord. We did not pursue Order 38 Rule 5 despite, because we wanted to file an application.
Have you served the notice?
Yes, my lord. It's
I
affidavit
am
of
for the
service.
respondent.
Yes. What is the contention?
Milord, I'll evict your lordship, Milord, within time. Milord, one thing, Milord, I want to point out, Milord, if Milord may kindly take Milord para 12 once, Milord. Milord, a wrong statement, Milord, an incorrect statement has been made on oath. Milord, it states that your petitioner states that from the said order dated 22nd of November 2024, your petitioner also
Yes.
came to know of the order dated 19th
Yes, I was
February
not aware that
2024
my GA1 was
prior
dismissed.
to.
I had got it corrected.
Milord,
Your lordship would remember on the correction when it came up.
Milord, may I,
19th
Milord,
November,
submit,
it
Milord.
is
Initially, Milord, GA1 was dismissed for default. Thereafter, Milord, the restoration application was filed. Milord, it was restored. But if Milord may kindly take Milord page 11 once, Milord, that's Milord the order, Milord, that the GA1 was restored. Milord. Thereafter, also GA1 was dismissed for default, Milord. Milord, on 14th of March 2024, Milord, an application for restoration of Milord order dated 19th of February 2024 was served on my advocate on record, Milord. Milord, they had the knowledge, they have Milord,
Milord, I take it back.
served
Milord, I
Milord,
kindly this paragraph be deleted. It is
Milord,
not
that
relevant
is
to
Milord,
at all.
that,
It
Milord,
is not
that
relevant,
cannot
Milord.
be.
Kindly delete it. It is
But
related
that
to suit.
cannot be. Milord.
Yes, it
Why
is.
you made this statement?
That
Milord,
cannot.
because the order it had, Milord, I didn't.
Then you have to file an affidavit to that effect.
I'll correct it, Milord. Kindly delete this.
No, Milord.
It is an affidavit.
I shall
On
file
affidavit.
an affidavit, Milord.
File an
Can I see? Because there has been a change of the advocate on record, Milord. The advocate on record was dealing with the matter. She left, Milord, the office because of that. That means, Milord,
But
this
my right
restoration
to
is
Milord take
pending.
appropriate step.
There are
Milord.
questions suffering for the plaintiff, sensations suffering for the defendant. The plaintiff has filed the present application being GA Com number 6 of 2024, praying for recalling of the order dated 22nd of November 2024, wherein this court has dismissed the suit being CS Com number 352 of 2024 for default. Counsel for the defendant has brought to the notice of this court of the statement made in paragraph 12 of the present application and submitted that the said averment made by the plaintiff is not correct. Police counsel for the plaintiff prays for time to file supplementary affidavit
Expunging the
for
statements in paragraph
expunging
12.
supplementary affidavit by praying for expunging paragraph 12 of the present application. In view of the submission made by the counsel for the plaintiff, the case is adjourned and the plaintiff is given liberty to file supplementary affidavit within period of 1 week.
Yes, Milord, this week only.
Within a week, after serving the copy to the learned counsel for the defendant, list the matter on 24th.
On Monday, Your Lordship.
24th.
Kindly keep it on Monday only. I shall file it within this week.
Then 13th. 13th January.
If my learned friend chooses to appear on a regular basis, this suit would have been disposed of.
I have
I can show 6 affidavit of service have been filed by me, Milord.
Milord,
Tomorrow
after
also
Milord
one
change
matter
of
was
Milord
fake.
advocate.
Nobody appear. Where are you?
Milord, on the contrary, Milord, I will tell your lordship, Milord, that Milord, I appear for Milord, the defendant. On the contrary, Milord, I can tell your lordship, Milord, this petition initially, Milord, GA1 filed for Milord interim relief dismissed for default in Milord February 24. Thereafter, Milord, another application filed, suit dismissed for default in November 24. In 25 comes up the application for restoration of the suit. And in the meantime, there has been served. In the meantime, and there's a petition, there's an averment. I've heard that there's an averment in that also. In the petition filed in, I have been served with the main petition, GA1 in February. In February itself.
We'll hear you.
Very
Yes.
well, my lord. Very well. Very well.
But item number 18, Suresh Shahani is there in this matter. Mr. Suresh Shahani, senior counsel, is there in this matter. I am praying for accommodation. Kindly fix it on 7th, my lord.
Which for the other side?
Other side, I can.
My lord, I am appearing for the defendant, my lord. I have no objection.
My lord, I am appearing for the plaintiff applicant, my lord. These both GAs have come on my application, my lord. I will seek your lordship's indulgence, my lord. On 7th of this month, your lordship have put my two matters at 3:45 p.m. So it will be, I shall be highly indebted if this matter is posted at 2 p.m. because the complex question of facts and law are involved in this matter, my lord, in both these GAs.
2 p.m. It's not already my diary is packed till February, I think so.
3:45, your lordship have already fixed, my lord.
I can fix on 7th, but I will not fix that.
Yes, as your lordship says. Your lordship.
Chance
Yes,
I can argue the matter, otherwise we'll see to that.
your lordship may give any time on 7th.
Time will not get. Only I fix the date matter on 7th because time already my diary is packed on that day.
My lord, then in first 5 matters, my lord, may I alternate pray for first 5 matters? If
I don't know.
my lord, it is too expensive for the litigant to bear the cost, my lord.
My lord, may I say this, my lord?
As your
Mr.
lordship,
Sahani's,
your lordship may post it for 7th as your lordship, please, my lord. Outside.
Yes, Mr.
my lord, Mr. Sahani's client in item number 19 has filed an application which bears the number GA-COM 8 of 2024. That is for the amendment of the plaintiff due to an amalgamation with one Divij Marketing Private Limited. I don't have an objection. My lord can allow that amendment.
What about 18? What are the applications? 18, 1, 2, 3.
Yes, my lord, GS6 at 7th. One is for the decree on admission. The second is for taking of the written statement filed after 120 days, though with the consent, wrongly consent was given by me, my lord, Sanjay, and law has been settled, my lord. There cannot be a estoppel against the statute. They are all similarly, there cannot be a estoppel against the wrongful concession given by the advocate. So that's why, my lord, the detailed argument has to be advanced, my lord. So
if there is an amendment which is carried out,
I shall be most grateful to if lordship will post this matter on 7th of January.
What about item number 19, GA8?
GA, my lord.
GA8, if my lord GA8 is allowed and
This
the
is
amendment is allowed, then they have to serve us a copy of
amalgamation, my lord, of the company. It should be allowed, my lord. The other side is also very gracious to accept it, my lord, Sanjay. I am grateful to the other side also, my lord.
I don't have any objections. Let them amend the plaint and serve a copy on us.
Can that may be disposed of today?
Man, GA-COM 8.
Yes, my lord, that can be disposed of today, my lord.
GA8 can be disposed of in item number 19.
Give the vacuum is suffering for the plaintiff, suffering for the defendant. As per the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 7th February. 7 January.
My lord.
Yes, my lord. I am highly indebted to my lord. Right.
8.
And item 19 may kindly be allowed, my lord, application.
8.
GA8 in item.
The plaintiff has filed the present application being GA Form 8 of 2024, praying for
amendment, my lord, of the plaint.
No, for your lordship.
I submitted that. Filed an application GA 8 of 2024, 2025, 8 of 2024, praying for amendment in the cost title of the plaint by deleting the name of the company, by deleting the name of the present plaintiff, and by Total including the address also.
Yes, but the new name is Divij Mercantiles Private Limited. There has been an amalgamation, according to them.
Divij Mercantile, huh? And
Yes, Mercantiles Private Limited.
Private Limited. Full stop. Consider the submission made by the counsel for the plaintiff. This court find the counsel for the defendant submit that they have no objection if the amendment as sought for by the plaintiff is allowed. Accordingly, prayer C
has to allow prayer A as well.
delay.
There has been some delay.
Prayer A, C, D, E.
And F, my lord.
A, C, D, F, A, C, D, E, F, G, and H. G and H. G Form 8 of 2024 disposed.
And my lord, the reaffirmed plaint may be served on us.
Yes. After the reaffirmation of the reaffirmation of the affidavit, the plaintiff is serve the amended copy of the print to the learned counsel for the plaintiff to the defendant.
I am beholden. I am beholden.
Yes. Next.
This matter, my lord, I'm telling on behalf of the plaintiff.
And I am applying for the defense.
20.
Yes,
20.
in this matter, my lord,
yes.
Order copy.
a degree was passed under chapter 13A.
Huh?
Degree was passed under chapter 13A, my lord. They preferred the appeal. In the appeal, the degree was set aside, my lord. The matter has come before your lordship.
My lord, on the last occasion, my lord kindly seize your lordship's last orders. My lord was pleased to, my lord, produce, my lord, the order passed by the Honorable Appellate Court and, my lord, the order Appellate Court. And, my lord, the order that was set aside, my lord, copy of that. একই অর্ডার চারবার দিয়েছি জাস্টিস অরিন্দম মুখার্জির অর্ডারটা and here is the order. Review order to the review.
You file the review application.
Yes, my lord, there or that order is also there. Here, my lord, is the order of the review.
Yes, review order is there.
Yes.
You have given the review. Where is the appellate order?
Then I have given. My lord,
No,
your
the
lord.
review order you have given.
No, my lord, the order.
What is the order dated?
Order dated, my lord, 6th May 2024.
And that has not been given. You have given the 7th August.
I am giving the.
Yes.
This.
Yes, you filed the written statement.
The written statement was filed earlier.
Thereafter,
my lord, they preferred that application for summary judgment. Now, my lord, that judgment was allowed. That application was allowed. We preferred the, my lord, appeal.
Correct. The appellate court kindly come to the last third page.
Yes.
Of the appellate court order.
My lord.
We expedite the trial of the suit. The appellant defendant has already been permitted to file written statement by the trial court. We order cross discovery and inspection. So where is the written statement?
The written statement was already filed.
Correct.
Thereafter, my lord, that was recorded there.
Now the suit is to be proceeded.
Is to be
Correct.
proceeded.
So written statement is on record.
Yes, it is there. My lord, only one humble submission, my lord, may I make. My lord, I am a late entrant, my lord, to the brief. My lord, after going through that, my lord, what I found, my lord, the point that has been taken, my lord, in the stay petition before the Honorable Appellate Court, my lord, it's not a deviation of fact.
But my lord, it's a clearer fact that was placed before the Honorable Appellate Court, which is really not present there in the written statement. What I have suggested them, my lord, my learned junior and my lord, the client, my lord, to come up with those facts, my lord, those are placed, my lord, in the stay petition, my lord, in those simple words, my lord, only the simple amendment of the written statement.
That is your
My lord, if your lordship today, my lord, pass an order of discovery and inspection so that I am not barred, my lord.
You can file application
I'm correct.
amendment. That is up to you.
Yes.
Whenever you file an application, the court will decide its own merit. So-and-so appearing for the plaintiff. So-and-so appearing for the defendant. Full stop. It is fine from the record. The defendant has already filed written statement. Accordingly, parties are directed to complete the discovery and inspection of the document within 3 weeks. Within 3 weeks from date. Full stop. Affidavit of admission and denial of the document be filed within a week thereafter. Full stop. In the meantime, the parties are also directed to exchange their suggested issues. Full stop. This is the matter on 11th of February 2025 for framing of issues. Next.
I am much obliged.
Number 21.
Your Lordship, I appear for the plaintiff, Your Lordship. As per Your Lordship's last order dated July 16, 2024, Your Lordship, the matter was settled between the parties, Your Lordship, and Your Lordship had allowed the prayers of the petitioner, Your Lordship. So accordingly, the suit can be disposed of, Your Lordship.
Plaintiff has filed present of paying for allowing the renter in case the fixed deposit. Yes. What is your suit for?
Your Lordship, the suit has been settled, Your Lordship. Your Lordship had also heard the matter last on July 16, 2024, Your Lordship. As per that order, Your Lordship had dismissed the GA also, Your Lordship. So accordingly, the suit can also be disposed of, Your Lordship.
Now that's why
Yes.
what is the suit for? Compelling the defendant, each of them, to issue and release the original bills and lading. Container number so and so and so. Now they have deposited the amount.
Yes,
and you
Lordship.
have received, taken
Yes,
out the amount.
Yes, Your Lordship.
But what is the amount? Alternative decree for the 7 crore 22 lakhs 16, but you have received only 8 lakhs. You're
Yes,
satisfied?
it was settled, Your Lordship. Yes, Your Lordship.
Settled.
Yes, Your Lordship.
Where it is settlement? Where is the
Uh,
settlement?
y- uh, Lordship, I have to take directions as for that, Your Lordship.
Have you received the instruction from the plaintiff?
Yes, Your Lordship, I am the plaintiff.
Bring the written instruction from your client.
Yes, Your Lordship.
They are satisfied with the amount. Then I will dispose.
Lordship, then kindly gives a short date, Your Lordship.
As per the so and so suffering for the plaintiff, none appears on behalf of the defendant. As per the prayer made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on when?
Lordship, any day next week, Your Lordship.
Let the matter appear on 28th January.
Wait for Lordship.
Next. Number 22. None appears on behalf of either the parties. No accommodation is sought for. Let the matter appear in the warning list.
Item number 23.
Same warning list.
Number 24.
Your Lordship, I am appearing on behalf of the plaintiff.
Hmm.
Your Lordship, we have been, the client has been sought for a change. So I am most have been praying for let the matter be go out of the list with the liberty to mention as the client has sought for a change and there are group of matters
Client
of
may
this
change or the client and tell your
Or a
client to
3
take
weeks time.
take back the brief from this court when they will make up their mind to continue
my
with the
learned
suit. Why the court should burden of the file of your client?
So we have been sought for a change.
So we haven't yet received the wakalatnama.
File
The
wakalatnama.
short date, my lord.
You want short date, he want out of the list, and third will
We were
come.
not informed about
Third will
a
come
new
saying
set
that
of
the
new set of advocate. That is why, Your Lordship.
As per the prayer made by the counsel for the plaintiff, the case adjourned. Let the matter appear in the combined monthly list of February 2025. Next.
Appearing for the plaintiff, my lord. This suit is wrongly appearing in the list, my lord. On
Why?
the last occasion, my lord, the suit has been decreed and disposed of. Let's check it. Order.
Decreed.
Yes, my lord.
If I had to draw a decree.
We have, my lord. The order, the decree has been settled, drawn up, everything complete, my lord.
हटा दो इसको क्या ऑर्डर करना है record the matter is already been disposed of by an order dated 10th April 2024. Accordingly, the matter be delisted from the list of this court. List of this court.
Number 26.
Delisted from the list of this court.
But I appear for the plaintiff. Lordship will adjourn this matter sine die because my lord, the defendant has been admitted into insolvency by way of the personal insolvency. My lordship will notice your lordship's last order. We were to ascertain the status of those proceedings, but that is still ongoing. My lord, the suit cannot proceed, my lord, at this
So
stage.
what do you want?
Lordship will adjourn the suit sine die. If and when those proceedings are concluded, then we'll take steps in the suit.
So appearing for the plaintiff. None appears on behalf of the defendant. Counsel for the plaintiff submit that the defendant is in CIRP and prayed for placing the matter out of the list. Liberty to mention. In view of the submission made by the counsel for the plaintiff, for the present, let the matter go out of the list. Liberty to mention.
Grateful.
Number 27.
My lord, I'm appearing for defendant number 2 in the matter.
Yes.
It's
Who is for the
last
defendant?
order, Your Lordship, had called for a report, Your Lordship.
Service of writ of summon upon you are appearing for?
defendant number 2. I had used a written statement in this case.
Personal service. Service upon defendant to the foreign country embassy could not be affected due to want of necessary orders. One duplicate copy of the writ of summon along with were written from the Indian post with the letter having no service to the foreign destination. Yes, no service. Go to the report.
Same.
Lordship, the region is blocked.
Huh?
Afghanistan, this region is blocked, Your Lordship. No postal deliveries.
Yes. So, what can be done? What is the suit for? Recovery?
Suit is for perpetual injunction.
Perpetual injunction?
Yes, it is regarding a counterclaim. I mean counter guarantee, which was there, under which they tried to invoke it, the party which is residing in Afghanistan, and that was injuncted from by our honorable court.
Yes, bank.
Yes.
Injunction against invocation of that contract.
So, take steps.
They can proceed in the suit because I have filed a written statement.
But, with regard to the main is there.
Yes. Parties
File
are all.
an application because they want the order of the court. So you file an application, the court will pass appropriate order, directing our embassy to take appropriate steps. As per the prayer made by the consul, so appearing for the plaintiff, so appearing for the defendant number 1. The report submitted by the department be kept with the record. After going through the report, learned counsel for the plaintiff prays for time for taking appropriate steps. In view of the submission made by the counsel for the plaintiff, the case adjourned. Let the matter appear on 7th February.
Grateful to.
Next.
28.
Lord, I appear for the plaintiffs, my lord. My lord, on the last occasion, the matter was adjourned due to, my lord, want of instructions, my lord. I have received instructions from my clients that, my lord, there's a possibility of settlement between the parties, my lord.
Yes.
My lord, let the matter be kept after 2 weeks, my lord. If the settlement is through, my lord, we'll apprise the court of that, my lord.
Written statement filed.
No.
My lord, that was disallowed by
That was
order
disallowed by
45.
the commercial suit. We could not file the written statement within time. Prepared an application, which was ultimately turned down. So we have
Lord, I'll hand
did
up a
not
copy
prefer an
of the
appeal.
order on the 5th of September 2023, my lord. The written statement will have
So appearing for the plaintiff, so appearing for the defendant.
instruction.
It is submitted by the learned counsel for the respective parties that the parties are trying to settle the matter between them out of court.
If my lord so desires, kindly refer it to mediation.
Lord, I don't have instructions today, my lord. If
Okay,
my lord, if
come
yes, my lord.
settle out of court. In view of the submission made by the counsel for the plaintiff, the case adjourned. Let the matter appear on 10th February.
I'm grateful.
29.
Deeply obliged.
Record and on. None appears on behalf of either of the parties. No accommodation is sought for. It is fine from the record the matter was listed on 22nd of December 2022. On the said date also none appears on behalf of either of the parties, even second call. But even second call, full stop. For the interest of justice, the case is adjourned. Today also when the matter is called, none appears on behalf of either the parties, no accommodation is sought for. Considering the above, this court finds that the plaintiff is not interested to proceed with the matter. Accordingly, CS 266 of 2022. Hey, नया नंबर आया नहीं? CS.com 44. No, 436. CS.com 436 of 2024 within bracket old CS number 266 of 2022 is dismissed for default. Interim order if any stand vacated. Full stop. na?
Lord, in this matter, I am for the plaintiff. In this matter, the defendant has not entered into any appearance. If your lordship kindly place the matter under the heading undefended suit. This is the copy of the report.
Writ of summons served?
Yes, ma'am.
Where is the report? Writ of summons.
My lord, that is missing from.
So,
my lord, this is the copy of the.
Give. Where is the report? With the writ of summons? This is a writ of summons, whether it is served or not. It is presented, plain writ issued. Where is the service? Bring the report. So and so appearing for the plaintiff. None appears on behalf of the defendant. Counsel for the plaintiff prays for time to obtain report from the department to ascertain whether the defendant and whether the writ of summons was served upon the defendant or the defendant has entered appearance or filed written statement. In view of the submission made by the counsel for the plaintiff, the case adjourned. Let the matter appear on 11th February.
My lord, so far as the entered into appearance by the defendant, I have already.
That is there, but unless.
May it please, my lord, I appear for the plaintiff.
My lord, I am on behalf of the defendant. My lord,
Lord, as per the
may I ask for a short passover, my lord?
Lord, as per the last order, my lord, they were to file their written statement. They haven't filed. So I believe passover will not help. The suit has to go to undefended suit, my lord.
Though the time period of 30 days has been expired, but the defendant has not filed it and let the matter appear on 3rd January.
Yes.
When you receive the writ of summons?
My lord, they had waived upon instructions they take to the That was by way of an email that is there in my lord's record. And that's also recorded, my lord, in one of the orders. I am unable to tell the order.
Waive the lodging of writ of summons by the plaintiff in the
Yes.
suit. So when it was served?
It has been served, my lord, by way of a letter on 2nd of September, I believe. 2nd of September. And my lord, 120 days has already expired on 2nd of January 2025.
2nd January?
Yes.
That's why it was fixed today.
Yes, that is why it has been fixed today. So the suit has to go to undefended, my lord. No application filed, no written statement.
Where is the notice of service of writ of summons upon the plaintiff?
Lord, on the right hand side, your lordship will see they have received it by way of hand. We have also served by way of an email.
2nd September.
Yes.
Yes, madam.
My lord, I am late by Mr. Porush Bandhavadar. Kindly let him come.
Let it be, my lord, pass over then, my lord. Let his senior come. But will my lord take it today? Because if it's passed.
Pass over.
Very, my lord, those two copies.
Take. इनको दे दो. Let. Pass over. Yes, next. अभी कौन सा पास ओवर हुआ? हाँ 32 कॉल करो.
32. Lordship, item 32, your lordship, I am for the plaintiff. This is a copyright infringement suit.
My lord, I appear
In
for the
reco,
defendant, my lord. My lord, there are
In
two
reco.
applications which are pending, my lord. My lord, if I may just indicate.
Which year suit?
Lordship, suit of 2023.
My lord,
So this has to go.
IP, your lordship, division has to be
my lord, may I
transferred.
just
first.
indicate one point, my lord. My lord, there are two applications which are pending in this suit.
Transfer over though. IP division, है ना?
IP. Up till 19 I am having. After 19, no.
My lord, because what had fallen from my lord earlier also was that there is an application pending before Justice Kapoor. Unless that is heard, this matter cannot be taken up. My lord had.
So now it has
My
to
lord.
be. Already Justice Kapoor is having.
My lord. My lord.
So and so appearing for the plaintiff, so and so appearing for the defendant. This court find that the suit is connected with the intellectual property matter and filed in the year 2023. Thus, this court is not having the determination to decide the matter. Accordingly, CS Com 472 of 2024 within bracket old CS 38 of 2023 is released from the list of this court. Full list of the department is directed to assign a new IP number in the suit and to place before the appropriate bench having determination.
Grateful, my lord.
33, my lord. I am for the plaintiff, my lord.
I am for the defendant petitioner, my lord.
My lord, they had filed an application for extension of the time to file WS. So far, my calculation is concerned, my lord, it has been already 120 days. And my lord, in my submission, my lord, even there is no written statement filed in terms of Order 8, Rule 1, because they have not filed any written statement in the department. They have filed the application, they have made it as like
What
an annex.
happened, if I may indicate,
Like and that too even beyond 120 days.
No,
that I will
subject to correction, my lord.
So, my lord, I have come with a list of dates for your lordship's perusal.
Someone was served.
My lord, it is.
Let it submit.
My lord, what had happened? There is a change of address of my client. for which we were not aware of that the suit is.
When the writ of summons was served. That is the crucial question.
Yes, my lord. Yes, my
crucial
lord.
point.
Yes, my lord. You,
My lord's 19th August order is the Bible in this matter.
yes.
Because it was a substituted service, they have accepted writ of summons. On 19th August order,
No.
it is reflected. It is reflected. 19th August order, my lord, kindly come to once. And Lordship has given the direction for computation of the filing of the return statement. It has been clarified in the order at the last paragraph of the order.
Counsel for the plaintiff has filed an GSJ praying for leave to service of writ of summons by a procured service. Now the advocate on the submitted, he has instructed to appear in the matter and he will receive the writ of summons. In the submission, advocate the plaintiff is directed to serve the copy of the print or the document within a week. When it was served?
My lord, it was served on, my lord, 23rd of December. That Lordship will find their endorsement. No, 23rd. Yes, my lord,
August, my lord.
23rd of August. My lord, here is the acknowledgement of
23rd August
19th August was the order.
23rd August you received.
I have received the copy of the plaint. Post we appeared on 19th of August, my lord. Yes.
From the date
19th
of
August.
receipt.
Yes, yes, yes,
So
yes.
23rd August.
23rd August.
August, September, now December.
December.
Now, my lord,
December, we obtained the leave from my lord on the 118th day.
Where is that?
Endorse যেটা করে দিয়েছিল।
and
Plaint এর।
but the application was filed on after 21st of December. That is because the master's signature is on 21st of
My
December.
lord, I have a photocopy of the endorsement when we took the leave. May I just hand up the original? ও আচ্ছা একবার তাহলে যচক and we had come prepared with the written statement on that date.
And written statement has not been filed in the department.
No, written statement endorsement.
Written statement has not been filed in the department.
Because we did not have, because my lord, the application was necessary
And that Lordship
in
will
order
find
to file the written statement.
this একটু দেবেন জজ সাহেবকে এটা? It is, my lord, I have marked it.
Let me.
Yes, my lord.
So this court has granted leave.
My lord,
Whether you have filed the written statement.
we had come prepared with the written statement as well as the application when we had obtained the leave, my lord. My lord was pleased to observe that upon scrutiny from the department, it will be accepted.
Common order.
Then we took the same to the department. We had taken out the application, which was also affirmed within that specified time. Since there was no 4 clear days mentioned, my lord.
No. My simple question, this court has granted leave to file the written statement in course of the day.
Yes.
Have you filed that? Have you filed that?
It is still lying at the department, my lord, unless
That's why I'm telling
yes. Absolutely.
My lord, there is, my lord, kindly see the, I've my lord handed up the
Still there.
report.
That's correct. Not what? You know, Mr. Alright.
The last
We have done
page
that
of the
exercise.
report, the department does not reflect that WS has been filed.
That will not reflect.
Yes.
Unless
It is
and
the
until
instruction upon the
yes.
department and also the bar, all the bar members, if any person,
Yes,
any of the
yes, we know, we are aware of this, that, my lord.
That's why I have instructed only it has to be kept in the record. It will not be taken on record with regard to in the list whether it is filed or
But
not.
my lord, kindly see, my lord, on 20, I have given my, kindly see when the
21st December.
Yes, application. The application, the master has signed it on 21st of,
No
that
problem.
is beyond 120 days.
That's why I'm telling on.
we had affirmed it
because
within 120
this
days, my
court
lord.
granted leave on 20 December. What is the, as per your calculator, 23rd August, the writ of summons
20th
was-
December is 120th day.
I am telling to 23rd of August 2024.
20, yes.
The writ of summons was served upon the
Yes, my
copy of the print was served.
Yes, my lord.
So it starts from that day.
That day.
23rd of August. Correct. 23rd of August. When the 120 days is over?
20th December.
20 December. So 20 December, the leave is granted. Let me see from the department.
Yes, my lord.
Let me see the department. Department has taken or not. It is
And
on
one humble submission, my lord. What
Because
my learned senior
my
friend is
depart-
saying is on his instruction. According to our calculation, 120th day is the next day. That is on the Saturday,
It cannot be
21st.
because my lord's order is amply clear. My lord, may I read?
December is the 120th day.
My lord, may I read? My lord, it is made clear that the time for filing the written statement by the defendant will start on the date when the plaintiff will serve the copy of the plaint along with the documents to the advocate on record of the defendant. So it is on the date. The time will start for filing the written statement by the defendant on the date when the plaintiff. So it is on 23rd from because since it is a substituted service.
So that is as per your calculation, it is 20 December.
Yes, 20th December.
That is the 120th.
So now, yes, if it is filed.
So this court, they have taken the leave from this court and they are having the copy of that.
So, my lord, if they have filed,
the written statement.
Yes, my lord, kindly call for the report, my lord, and my lord, kindly see on 20th December.
So appearing for the plaintiff, so appearing for the defendant. The defendant has filed an application being
1 of
3 of 2024, praying for extension of time to file return statement. Please, counsel for the defendant submitted on 20 December 2024. This court has prayed for leave to file return statement, and accordingly, this court has granted leave to the defendant to file return statement in the department, subject to acceptance by this court, and accordingly, the same was filed on 20 December 2024. Counsel for the defendant plaintiff submitted 20 December 2024 is the 120th day. If the defendant has not filed the written statement on or before 20 December 2024, the defendant cannot be allowed to file the written statement. Though the counsel for the defendant submitted that as per the leave granted by this court, the plaintiff has filed the written statement in the department on 20 December 2024. Accordingly, the department is directed to place the original written statement before this court on 7th of January 2024 to ascertain whether the written statement was filed by the defendant on 20 December or not. This is the matter on 7th of December.
My lord, only I have given that High Court filing document, my lord. Kindly see the 20th December case status, my lord. I have handed up.
Okay. See, the contention.
No, had they given the WS, the WS would have.
No, see, as per law, as per your act, our CPC and the Amendment Commercial Court Act.
Lordship.
Correct.
Lordship.
There is no mentioning with regard to the filing of the application for extension of time. It is the discretion of the court for extension of time within the 120th day. So this is discretion of the court. With regard to filing of the application, that is governed by our original side rules, Chapter 9. So master summon has to be taken off. So whether they filed the application or not, that is a subsequent issue.
Yes.
Now, first issue is
within 120 days, court discretion. But court discretion.
Only the written statement has to be, my lord, looked
on record.
On that date.
7th February.
Yes.
7th
January, my lord.
Take this.
ঠিক আছে হয়ে গেছে
আরো কাগজ আছে তুমি বলো না আমি সাই দিয়ে দেবো
my lord is fixing any time or it will
no come on
next এই আরেকটা আছে হ্যাঁ এটা আমার বোধ হয় আমার একটা ডকুমেন্ট গেল
না এটা আমাদের
এই কাগজটা আমার
item number 14. Yes.
My lord, item number 14, this is my application.
Yes. Madam.
Yes, my lord.
Who is the attesting witness?
Mr.
Huh?
Yes, my lord. In the will, he has used his nickname, Mr. Gopal, and actual name is Sandeep Verma. Annexure A, my lord, is Aadhaar card.
Correct.
Mr. Sandeep Verma. That is why, my lord, we have used Gopal Verma alias Sandeep Verma. And he before the oath commissioner, my lord, he put his signature.
But in the will, it is not the signature. It is not the name of that he is having.
Yes, my lord.
Correct.
Yes,
And
my
in the Aadhaar card or in the this Aadhaar card,
Aadhaar card, his name is Sandeep Verma.
Sandeep Verma.
And his nickname is Gopal Verma, which is mentioned in the last will.
No, last will it is not a nickname. Last will it is as a name of the
Gopal Verma.
person.
Yes, my lord.
Gopal Verma, not the nickname. Gopal Verma.
Yes, my lord.
And kindly see that this address. So I wanted to, but this matter is to be taken in the solemn form. The witness is to come on dock.
My lord, that is why.
And I am giving one chance.
Yes, my lord.
If there is a wrong, you can take the apology from this court. The court will accept. If you will not take the apology, and I will examine the witness on dock,
My lord.
then it will be difficult to you, to the witness, and who has affirmed this affidavit. Or three persons will be very difficult.
My lord, my advocate is not here today.
Whatever, I don't know.
But what I have informed.
Because you persons are the court officers. That's why I am not signing any of the order sitting in the court. This is the way. Kindly see the photographs in Annexure A.
Yes.
Original photographs and Aadhaar card photograph.
My lord, kindly give me a direction to prove this will. By
Not prove with this. I wanted this witness. This
Yes,
person
my
should
lord.
come
Yes,
in
my
the
lord.
dock.
Yes, my lord. Kindly give me a date.
The matter was taken of. The matter was listed on 2nd of December, 2nd of January 2025. And this court, after considering the documents, had dictated the order. But while signing the order, this court find that in the will, there is one attesting witness, namely Gopal Verma, having address AE-326 Salt Lake City, Kolkata, 70064. But in the affidavit affirmed by the said witness as attesting witness of the will, has stated that his name is Gopal Verma alias Sandeep Verma, son of late Naresh Verma, Naresh Kumar Verma. Naresh Kumar Verma. In the affidavit, the said person has also disclosed the copy of the Aadhaar card, wherein the name is appearing at Sandeep Verma, care of Naresh Kumar Verma. And in the Aadhaar card, the said person has also disclosed the original photograph. And the Aadhaar card is also having the photograph. This court find that both the photograph is not. This court find that both the photograph of the not the similar person. Accordingly, this court has not signed the judgment, and the petitioner is directed to produce the witness on dock to prove the will. Let the matter appear on.
Indeed.
Let the matter appear on. आज क्या तारीख है? 3 तारीख. On 16th January 2024 for examination of the witness, attesting witness Gopal Verma.
My lord, this is my application. My lord, my application seeking amendment of the petition of for grant of letters of administration, my lord, as well as the affidavit of assets. My lord, the reason why I'm seeking this amendment is, my lord, the deceased jointly owned a bank locker along with her daughter who is also deceased. By an order of court, my lord, now the locker has been opened and my lord, the items lying thereat have been inventorized. Now, my lord, consequently now, my lord, my affidavit of assets need to be, my lord, changed. My lord, I need to put in the value of the articles that were lying in the locker. My lord, will straight away look into page 7, my lord, the order, after which, my lord, I opened the bank locker. Well, the bank locker was opened.
Where is the amendment?
My lord, the proposed amendments.
Page 20.
My lord, it starts from page 15. My lord, first I have the affidavit of assets.
Page 15.
Yes. My lord will see the last line, the last sentence, my lord.
Locker, the amount was lying.
Yes, my lord, the jewelry was lying in the, yes. Yes. My lord, now, my lord will first look into the order once, my lord, the order passed by Justice Pattanayak. My lord, that is at page 7.
Yes.
My lord, the effective part is on the next page, where, my lord, my prayer A of the master summons was allowed.
Okay.
Now, my lord, thereafter, my lord, the inventory has taken place. That is at page 9.
Yes.
My lord, the owner of the locker, my lord, may I just point out, was one late Protima Chaudhary, my lord, because of whom we are before your lordship. And my lord, the other is the daughter, late Chandra Das. My lord, the next application is because of her. Now, my lord, the articles lying your lordship will find in serial number 1 are basically gold ornaments and silver ornaments. And thereafter, my lord, deeds original.
The valuation.
Yes. Now, my lord, the valuation is at page 13.
11 lakh 40,000.
Yes. Now, my lord, this has to be incorporated.
This is 11 lakh.
Yes.
So now,
Now, your lordship will find, my lord, the value of the estate naturally goes up. My lord, that is at page 15. My lord, now it goes up to 35 lakhs. My lord, I had filed it with stating it as 29. And my lord will then look into page 17. My lord, under serial item number 11, my lord, A 50% share, my lord, that time it was not known. So, my lord, now 11 lakhs gets broken into 50-50 because, my lord, I owned 50. Thereafter, my lord.
These are the thing.
Yes,
These are the only.
Yes, yes. My lord, this is the only.
So and so appearing for the petitioner. The petitioner has filed the present application being GA2 of 2024, praying for amendment in the probate application. Probate or letters of
letters of administration.
Amendment in the application for letters of grant of letters of administration, as well as affidavit of assets. Counsel for the plaintiff submitted after filing of the application for grant of letters of administration, in terms of the order passed by this court dated 25th of June 2024, the locker was open, and after the opening of the locker, inventory was made, and the value of the jewelry lying in the said locker was conducted, and thus the plaintiff and thus the petitioner intend to amend the application as well as affidavit of asset. Considering the submission made by the counsel for the petitioner, this court find that the amendment as sought for by the petitioner is formal in nature and will not change the nature and character of the application. Thus, prayer A, B, and C. No, A and B. A and B of the master summon is allowed. GA2 is disposed.
I'm so grateful. Now, my lord, the next application, my lord, the next item in your lordship's list today, my lord, pertains to the daughter. My lord, late Chandra Das. My lord, the order passed.
The similar?
Yes, my lord. My lord, this is for the remaining 50% of the law.
Dispose of, huh? GA2.
I'm so grateful, your lord.
Next.
Number 17.
Lordship, I'm for the executor.
Yes.
I'm paying for my grant of probate.
You are the executor?
Yes, your lordship.
What is your name?
Barno Basu.
Barno Basu. Where is the will? Ready matter?
Yes.
Where is the will?
Annexure B, your lordship.
Yes. Where is the name of the executor in the will?
Barno Basu, executor.
Where is the name? Where the name of the executor is appearing in the will by appointing him as executor?
Page 14, para 8.
I appoint Barno Basu, executor. Yes. What is the date of the will? 15th November.
Yes, 15 November 2019.
2019. Yes. How many legal heirs?
So 3 legal heirs.
Where is the attesting witnesses?
Attesting witness Orpita Ghosh.
Legal heirs?
Legal heirs Shubhra Datta, Shebanti Vasu.
Wife,
I will,
daughter,
yes, wife, daughter, and son.
wife of the son, daughter-in-law.
Your Lordship, page 5, para 9.
Yes. What third? Who is the third? Srilina Datta. Who is
Srinath
she?
Datta is a wife of the predeceased son,
Predeceased son.
Shubhajit Datta.
Okay. All have given the no objection.
No, no objection. No objection given.
Where is that? Attesting witness. And who is the attesting witness?
Attesting witness Arpita Ghosh.
Where is that name? Arpita Ghosh.
Consent affidavit given by Shubhra Datta. All
Arpita
the legal
Ghosh.
heirs.
Daughter of Pradeep Ghosh. So. I am the attesting. Yes. Barna Basu. Sarlina Datta. Sebanti Datta. Subra Datta. They are the three persons.
Yes, 3 persons. Gosh.
When did this is died?
This is died 1st September 2023.
Where is the death certificate? 2023. Extensive suffering for the petitioner.
Okay.
The petitioner has filed the present application for grant of probate of the last will and testament dated 15th November 2019. Counsel for the petitioner submitted. The testator has appointed the petitioner as sole executor of his last will and testament. Police. The testator died on 1st September 2023, leaving behind 3 legal heirs, that is wife, daughter, and daughter-in-law. Counsel for the petitioner submits that all the legal heirs have filed their affidavit of consent stating that they have no objection for grant of probate to the petitioner. Full stop. The counsel for the petitioner further commented the one of the attesting witness has also filed the affidavit stating that the testator has executed his last will and testament in her presence while possessing good health and fit state of mind by appointing the petitioner as sole executor of his last will. Counsel for the petitioner submitted the petitioner has proved the will and is entitled to get the probate. Consider submission made by the counsel for the petitioner, produced the original will, copy of death certificate, affidavit submitted by all the legal heirs as well as the attesting witness. This court find that all the 3 legal heirs in their affidavit of consent have categorically stated that they have no objection for grant of probate of the last will and testament to the petitioner. The attesting witness in her affidavit has categorically stated that the testator has executed his last will and testament in her presence and in presence of another attesting witness while possessing good health and fit state of mind. Fit state of mind. Considering the above, this court find that the petitioner has proved the will and is entitled to get the probate. Accordingly, the department is directed to issue probate after compliance of all formalities. At the time of grant of probate, the copy of the will be made as part of the probate. PLA number and disposed of. Next.
Number 18.
Yes, Your Lordship, I'm for the execute.
Yes. Where is the will?
Say annex, Your Lordship, annexure here. Annexure B of page number 40.
Where is the name of the testator executor?
Sole executor in page number 25.
Page
25. Para 10. Sole executor Devdeep Karanjia.
Devdeep Karanjia. Yes. When he died?
13th October 2023 at Bellevue Clinic.
13th October?
13th October.
Yes. How many legal years?
Five legal years.
Yes. They filed the affidavit?
Yes.
Affidavit?
Yes. Yes, Your Lordship.
Yes. Who is the attesting witness?
Assistant Nirupam Bakshi. We have filed the affidavit also.
So suffering for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament dated 16th June 2021. Counsel for the petition submitted. Testator has executed his last will and testament in presence of two attesting witnesses by appointing the petitioner as his sole executor of his last will and testament. Counsel for the petition submitted. The testator died on 13th October 2023, leaving behind 5 legal heirs, that is mother, wife, 2 sons, and 1 daughter. All the legal heirs have filed their affidavit of consent stating that they have no objections for grant of probate or to the petitioner of the will dated 16th June 2020. What is the date? 2021. Counsel for the petition submitted. Out of the two attesting witness, one of the attesting witness, namely Nirupam Bakshi, has also filed the affidavit stating that the testator has executed his last will and testament in his presence by appointing the petitioner as sole executor while possessing good health and fit state of mind. But the learned counsel for the petitioner produced the original will, death certificate, affidavit of consent of the legal heirs, affidavit of the attesting witness. This court find that all the legal heirs of the deceased testator have filed their affidavit of consent stating that they have no objection for grant of probate to the petitioner. The attesting witness in his affidavit has categorically stated that the testator has executed his last will and testament in his presence by appointing the petitioner as executor while possessing good health and fit state of mind. Considering the above, this court finds that the petitioner has proved the will and is entitled to get the probate. Accordingly, the department is directed to issue probate to the petitioner after compliance of all formalities. At the time of grant of probate, the copy of the will be made as part of the probate. PLA number 776 disposed. Next.
Your Lordship, I'm from the executor.
How many cases you are having?
3 cases.
Yes. Where is the will?
Your Lordship, page 8.
Shivdas Banerjee.
Yes.
Shivadas Banerjee.
Executor
Yes.
Devidas Banerjee.
Where is the name of the executor?
First paragraph of Annexure A.
First paragraph.
In page 8.
Yes. Where is the executor name? Sole executor. Devidas Banerjee.
Devidas Banerjee as the sole executor.
Is the petitioner herein?
Yes.
Devidas Banerjee, yes. Where is the witness? Attesting witness? Two attesting witness.
Witness Shutanu Chakraborty.
Kalimuddin Mandal.
And separated affidavit file.
What is the date of death?
Date of death 15th February 2023.
Where is the legal heirs?
3 legal heirs.
Elder daughter, younger daughter. 2 daughters only. No
Yes,
son.
2 daughters.
Where is the wife?
Predeceased wife.
Predeceased wife.
Death certificate already given. Your Lordship, page 14, ancestry, C, and wife.
Sense appearing for the petitioner. The petitioner has filed the present application on grant of probate of the last will and testament dated 8th of April 2009, 8 April 2009, executed by the testator Shiba SHIBA Sivadas Banerjee BANERJI Banerjee. Will counsel for the petition submitted. The testator has executed his last will and testament by appointing the petitioner as the sole executor of his last will in presence of 2 attesting witnesses. The testator died on 15th of February 2023, and the wife of the testator was the predeceased to the testator, who died on 12th of April 2008. 12th April 2008. Counsel for the petition submit that the testator died leaving behind 3 legal heirs, that is 1 son who is the petitioner herein, and 2 daughters. Both the daughters have filed their affidavit of consent, stating that they have no objection for grant of probate to the petitioner of the will. Petitioner in terms of the will. Police counsel for the petitioner submit that out of 2 attesting witness, one of the attesting witness, namely Santanu Chakravarti.
Sutanu Chakravarti.
Sutanu, SUTN, Sutanu Chakravarti has filed his affidavit of consent, and his affidavit is stating that the testator has executed his last will and testament in his presence and in presence of the other attesting witness, another attesting witness, while possessing good health and fit state of mind, by appointing the petitioner as sole executor of his last will. Counsel for the counsel for the petitioner peruse the original will, death certificate of the testator, death certificate of the wife of the testator, affidavit of consent of both the daughters, and the affidavit of the attesting witness. This court finds that the attesting witness in his affidavit has categorically stated that the testator has executed his last will and testament on 8th of April 2009 in his presence and in presence of the another attesting witness, while possessing good health and fit state of mind, by appointing the petitioner as sole executor of his last will. Considering the above, this court finds that the petitioner has proved the will and is entitled to get the probate of the last will and testament dated 8th April 2009. The department is directed to issue probate to the petitioner of the will dated 8th April 2009 on completion of all formalities. At the time of grant of probate, the copy of the will be made part of the probate. Yes. 306 is disposed of. Next.
But I appear for the respondent in this application for revocation of grant. But my learned senior friend had.
For the petitioner, on last occasion, we have completed, my lord.
Yes.
They are to reply. My lord, I have showed certain judgments as also, my lord, certain paragraphs. My lord has taken note of it. I hope that note is there with your lordship.
Yes.
Yes, my lord, may I start? But the ground for revocation which has been taken falls under 263A, illustration 2, which is the application is defective in substance, because they, according to them, they were to be cited by a special citation, which was not done. Well, when the application for grant of probate was filed, the averment made in the application was, well, I am the beneficiary as well as the executor. Well, I am the brother of the deceased. Now, my learned senior friend appears for a legal heir of the husband of the deceased. The property belonged to the husband. The husband passed away in 1990. Thereafter, we had the deceased and her husband had a son who also passed away in the year 1997. Thereafter, the deceased was on her own, that the testator. I used to take care of her, and I have explained that in my affidavit in opposition to the application for revocation of grant. But the averment made in the application for grant of probate, insofar as the legal heirs of the husband is concerned, is that I could not trace out any legal heir of the husband, of the deceased husband, and that is why citation is required to be issued. Now, they have come up with certain documents, WhatsApp messages, etc., to show that I knew about the petitioner here, the petitioner in the revocation. Now, my lord, even if I assume that I knew about the existence of one of the legal heirs of the deceased husband, my lord, my averment is not false to the effect that I did not know about the address. I had to include the address of the legal heirs of the husband so as to issue the special citation. And that is why I opted for general citation, because I did not have the address, I did not have the particulars. And the general citation was issued, advertisement was made in the Sunday edition of two newspapers, one vernacular and in English, pursuant to orders of court. Now, first, obstacle or the first factor which is to be taken into consideration as per my submission is that why the petitioner here could not approach this court after citation was issued, before grant of probate. Now, there is only one sentence which is pleaded in the application for revocation to the effect that they did not know about the advertisement made in the newspaper. Why? Because they subscribed to another newspaper, and that is why they were unaware. That is the only explanation why they could not approach this court. But thereafter, what they have stated is that I knew about them, I ought to have called upon them to join or to participate in the proceedings. And the third allegation which is made, which is, in my respectful submission, has to be taken into consideration, along with whether general citation or special citation was at all required, is that whether the will is forged or whether the will is not genuine. Lordship knows, my lord, I don't need to cite judgments that mere non-citation of a particular person without issuance of general citation or a special citation is by itself not a ground for revocation. But although it is a ground, it is a valid ground, but that by itself will not persuade your lordship to revoke the grant. The main factor which is to be considered is whether there is a likelihood of proof that the will can be genuine or is can be not genuine and is forged. Now, my lord, there are two paragraphs in which the allegation has been made with regard to the authenticity of the will. Now, kindly takes, my lord, the application of revocation. That kindly takes paragraph 25, page 16. Paragraph 25, the allegation is, the petitioner states that the will in question is not a genuine one and suffers from inter alia the following suspicious circumstances. Though the testator was the permanent resident of Kolkata, she allegedly executed the will in Shiliguri. Though the Shiliguri registration office is nearer to her place of residence at Shiliguri, the testator did not get the will registered. C. Though Abha Shaha died on 13th May 2021 and one of the witnesses of the said will, Sri Amol Kumar Shikdar, being husband of his youngest sister Jhumur, and a cordial relation exists between them, even the executor took a long 1 year, 4 months to put forward the will for probate before the learned court for reasons. I do not know what this means, but what appears is that I should have been aware of the will and I should have promptly applied before the court for grant of the probate because I knew about the existence of the will. Now, my lord, insofar as the first ground is concerned, that though the testator was a permanent resident of Kolkata, she executed the will in Shiliguri. Why did the testator had to execute the will in Shiliguri is a question which your lordship has to decide. My lord, in my affidavit, I have explained the circumstances in which the testator traveled to Shiliguri because the testator was living alone. Her youngest sister was residing in Shiliguri along with her husband. So the testator, at the fag end of her life, my lord, wanted to travel to Shiliguri and stay with her sister. So while staying with her sister in Shiliguri, she wanted to execute this will, and that is the reason why the will was executed in Shiliguri in the presence of all her family.
Who is the beneficiary?
But I am the beneficiary is the brother of the testator, who was not there in Shiliguri at the time of execution of the will, who was staying in Kolkata. I appear for the beneficiary, who had to travel to London and here and there for professional purposes from time to time. Now, my lord, this is so far as the first ground of challenge to the will is concerned, that why has it been executed in Shiliguri? That, in my respectful submission, is not sufficient enough to revoke the grant of probate in respect of the will in question. Now, my lord, the lordship will kindly note there is no allegation of forgery insofar as this ground is concerned. The second ground is the will is not registered, although the registration office was very near to the place where the will was executed. Lordship knows the will need not be registered. It's not a mandatory pre-requirement. So, my lord, the non-registration of a will not call for revocation of a grant of probate. My lord, the third allegation is, why did I wait for 1 year, 4 months after the execution of the will or after the demise of the testator to approach this court? My lord, lordship, my lord, is well aware that, my lord, I have a right to approach the court, my lord, Article 137. Even thereafter, my lord, I'll have to furnish sufficient explanation for delay. My lord, I'm well within the period of limitation. And even then, I have explained why I could not approach the court before 1 year, 4 months after the demise, is that, my lord, I was not aware of the will. It is only after the demise of the testator, and it was one of her wishes, my lord, which I gathered from her sister, is that, my lord, I will not be made aware of the execution of the will till her demise. So, my lord, as soon as I became aware of the grant of the will, that I approached the court. Now, my lord, kindly takes paragraph 26. These are also certain allegations have been made in respect of the genuinity of the will. Your petitioner further states that the will is not a genuine one and the same does not bear the signature of Abhashaha since deceased inter alia for the following reason. But I do not know the same does not bear the signature of Abhashaha. What does it mean? Because the will has the signature of Abhashaha. But A, the signature of the deceased known to your petitioner is totally different from that of which is appearing in the purported will. My lord, what is the signature known to the petitioner? We do not know. My lord, there is no document on record, nothing has been produced to the effect that the actual signature of Abhashaha is different from the one which is appearing in the will. So, my lord, this allegation goes, my lord, they cannot be taken into consideration. The second allegation is, the signature of the deceased in her bank accounts and other documents are totally different from that of which is appearing in the purported will. My lord, what is the signature appearing in the bank account? What are the other documents which my learned senior friend wants to rely upon? My lord, we do not know. My lord, these are vague allegations, my lord, which have been made. My lord, there is no substance at all. Now, my lord, A and B, and then my lord, C is, it is highly suspicious a full match of both the figures of age mentioned as 75 years of then surviving testator in the said purported will.
See, this all the things with regard to the proof of the document.
Yes, proof of the
That is
document.
the merit of the matter. Now,
Yes.
only the question here, the 263, whether the ground set out in the 263 is covered.
Yes,
for
my lord.
revocation.
Yes, my lord. Kindly.
Correct.
Yes, my
So
lord.
now, in that, kindly you are having the
Yes, ma'am.
act.
Yes,
Kindly come to the illustration
Yes.
2.
Yes. Illustration 2, the grant was made without citing parties who ought to have been cited. That is the ground.
That is the ground.
Yes, my lord, and that read with 263A, the proceedings to obtain the grant were defective in substance. So, my lord, if illustration 2 is present in a particular case, that will lead to the proceedings being defective in substance.
Correct.
And in that circumstances, the court will revoke the grant.
Correct.
Now, my lord, whether the proceedings were defective in substance has to be proved not only on the basis that the grant was made without citing the parties, but also on the ground that the will can be inauthentic or ingenuine, or there is sufficient explanation or suspicious circumstances which is present in the case to doubt the veracity of the will. My lord, I have the judgments with me, my lord, which say that merely because one of the parties who ought to have been joined as a party, who ought to have participated in the proceedings, has not been cited, is not a ground enough for revocation of the grant of probate. There has to be other circumstances. That itself is not a ground. There has to be other circumstances. That kindly takes. Now, this is a judgment reported in 2010, Volume 5, Madras Law Journal, page 432. A copy. Okay. But you will kindly have paragraph 1 of this judgment. My lord, may I place the facts in gist? My lord, here, my lord, I'll indicate, my lordship need not go through paragraph 1. My lord, here the will was executed on 17th June 1987, and the application for grant of letters of administration was made in 1996. My lord, there is a gap of 8 odd years. Thereafter, my lord, the application for revocation of a grant of letters of administration was made on the ground that there is a subsequent will, and the will is the will of which grant has been made is not genuine, and also that one of the parties, which is the petitioner in the revocation, has not been cited. No special citation or general citation was issued to him. Now, my lord, kindly takes paragraph 7. My lord, I am not troubling your lordship with multiplying the judgments, because the judgments have been referred to in this particular judgment. Kindly takes paragraph 7, where the judgment of Anil Bihari Ghosh of the Honorable Supreme Court has been referred to. It is relevant to, lordship will kindly take the second sentence of this paragraph. It is relevant to point out to the observation made by the Honorable Supreme Court rendered in the case of Anil Bihari Ghosh, that annulment of the grant of probate is a matter of substance and not a mere form. And the court may still refuse to grant annulment in cases where there is no likelihood of proof being offered that the will admitted to probate was either not genuine or had not been validly executed. Bearing in mind the said observations made by the Honorable Supreme Court, admittedly in the present case, validity or genuineness of the will has not been challenged. Well, in this particular case, the validity of the will was not challenged. But my lord, why I am citing this judgment is there were two allegations. One is the consent affidavits were obtained by fabrication. The consent affidavit of the person who had applied for revocation, the signature of that person was forged. The second allegation is he was not cited. Now that is why, my lord, kindly takes paragraph 9. These are the grounds on which the petitioner in this case had applied for revocation. It would appear on going through the averments and the allegations made by the applicants that they seek to challenge the grant on 3 grounds. No notice of petition for grant of letters of administration was served on the petitioners, who are also the beneficiaries in the will. Thus, the proceedings in obtaining the grant is defective in substance. Second ground is the grant was obtained fraudulently, and third is there was no filing of accounts. In our case, the third ground is not there. No filing of accounts is not a ground taken. The first ground is what the notice of petition was not served, and that is why the proceedings is defective in substance. Now, my lord, here, my lord, paragraph 12, my lord, kindly takes. This is the first ground, no notice. As far as the first ground is concerned, the defective in substance as set out in clause A of 263 of the Act is concerned, it must be of such a character as to substantially affect the regularity and correctness of the proceedings. Absence of service of special citation on a person who ought to have been served is a just cause, but if the non-cited party had knowledge of grant of letters of administration, or if he or she is not prejudicially affected thereby, the grant need not be revoked. Absence or non-service of special citation to the persons who ought to be cited is no doubt a good ground for revocation, but however, it is not an absolute right, and other circumstances has to be taken into consideration before looking into the said aspect. So, it is not an absolute right, and other circumstances. Now, what are the other circumstances? Is whether the will is genuine or not, whether the person who is applying for grant of probate is prejudicially affected or not. Now, my lord, the question of being prejudicially affected would arise only if the will is not genuine. If the will is genuine, then the person applying for grant of probate being prejudicially affected will not even arise. So, my lord, first the applicant for revocation of grant has to establish that the will is not genuine. Now, my lordship has seen the allegations made as to the veracity of the will, as in the application. Lordship will see that none of the grounds, as stated in those paragraphs, would deal with the genuinity of the will. It's only the circumstances. Why did she have to execute the will in Shiliguri? Why did she not register the will? And why did I wait for 1.5 years to apply for grant? Well, these are the grounds which, in my respectful submission, are not sufficient enough to doubt a particular will. Had your lordship, had my learned friend participated before grant of probate, had my learned friend lodged a caveat, I would have had to prove the will. At the time of proving the will, what would I have to prove? The execution, the attesting witnesses would have to come and say and prove that the will was executed in their presence, the will was executed by the testator, and the testator was of sound mind. Well, these are the three factors which I would have to prove if my learned friend was there before the grant. Malad, parallelly, if my learned friend has come now after the grant of probate, what are the same considerations are required to be proved, whether the will was executed. Correct. So, my lord, if those circumstances are proved and the attesting witnesses have given their affidavits saying that they have seen the testator and that she was of sound mind, then the question of veracity of the will being doubted by a person who was not even present or who was not even in touch with the testator would not arise in the facts of the present case. So, my lord, I'll read on the paragraph. My lord, it's already 1:20. I can come back. My lord, I will take 10 to 15 minutes time to conclude. My lord, she will keep it on Monday. My lord, I'll check.
So appearing for the petitioner, so appearing for the respondent. Counsel for the respondent has argued at length, but due to paucity of time, hearing could not be completed. Let the matter appear on 7th January.
Grateful.
As parted.
No.
Happy New Year.
Thank you.
I have appeared before you before this. The only thing is, before this is the witness action, though I'm not attributing anything against any of the parties or something, we have been given a way back. We have been given a copy of the affidavit and evidence. But the thing is, this is an incomplete copy. The documents have not been given to us.
Judge's brief
has been supplied to them. Has been supplied.
That is there, but the thing is, the documents which they will rely upon here, that's not there.
No, that is the only, they have to give the original. It has to, they will refer the JBD.
No, that is not there with us.
No, they will
I have the
refer the
originals
JBD.
with me.
No, they
I
have
have a
not
copy for my
Yes,
learned friend
they have
as
not
well.
given us that.
I will give it as an.
Okay,
I can
the-
give it right here and now.
Problem, Your Lordship, my problem here lies in only 4 or 5 documents. We're just going through 4 or 5 documents. Because if I have to object on the admissibility of the documents and being marking of them, I need to take instructions. I need to take instructions. I cannot take instructions standing here.
No. See, this court will not allow the party to go beyond the JBD.
No,
Judge's brief
that is
and
very
judge's
well.
brief
Your Lordship.
document has been filed only after the inspection of the document.
Your Lordship,
No, my lord.
no.
Here, my lord, they had not entered appearance.
That is
it
why
was marked as an undefended suit.
That is why
I have the certificate from the registrar as well, and I was in the course of my examination in chief when they appeared and filed 2 applications thereafter. And in the first application, my lord had imposed cost of 25,000 for the purpose of because the application was for remanding the matter back to mediation, whereas this is the whereas this was at the stage of trial. And my lord, after that there was another application which was never moved. And my lord, whether the payment
Your
of
Lordship, that
25,000 cost has been paid or not is also to be ascertained. But my lord, on the last occasion, my lord had fixed today for the purpose of the witness to be here. The witness is here, the originals are here.
all
My lord,
that
I
is
will
now,
continue.
Your Lordship now looks at the situation, which is because I have never had a chance. If they don't give me the full documents, I cannot do the entire objections or anything of which I have to take with regard to the documents. I cannot do because I have not filed a written statement here.
You have not filed the return.
I have not, because I was, that certificate was there because we had not tendered appearance within 120 days. So I have not filed.
Correct.
I have filed an Order 7 Rule 11 application, which is fixed for hearing on 10th.
Correct.
That is next Friday. That's a different issue. I'm not getting into that. But the thing is now, at this stage, if I am not given time to first get the documents and take instructions and at least object to the documents which are incriminating against me, then the case is going to be marked and the documents are going to be admitted without me getting an opportunity to do anything. But irrespective of the fact whether it has been undefended suit or not, I am entitled to cross-examine the witness after getting proper documentation and after getting the time to take instructions. Your Lordship, may I only indicate?
With regard to taking instruction, cross-examination, there is no difficulty. I will give.
Right, but
with regard to the document, when
admission.
you file the affidavit examination in chief?
My lord, I had filed it in
When
September.
you served?
September, my lord, they appeared on the
Your
on
Lordship, may I also say?
24th September. I have served them
So why
in
you
court.
not serve the document?
My lord, though it is the same document, same set. It is
Not at
the
all.
same set as
Your
that.
Lordship, I have been given this, and this is the
No,
set
the
of
judge's
documentation.
brief has also been supplied.
Judge's
My lord,
brief
the
is
judge's
there.
brief was supplied. The same documents are appearing here as well, and it is referred to in the plaint as well. I have not added any other document save and except the certificate from the registrar. That is the only additional document, and the board resolution. These are the 2 documents which I am going to rely on now.
So
No
the
new
judge's
document has been brought in.
Judge's brief is with you. And the judge's brief of the document has been filed after the
In September, my lord, 24th September, when they were present in court, we had handed it over.
Then,
I have no idea.
then what can be done?
Your
It is
Lordship,
witness action.
very well, Your Lordship.
Even affidavit and the judge's brief served on the same day in court.
Okay.
I don't, Your Lordship, this was served to us sometime in July. I don't think the judges, my advocate on record may have been present. There is
My
no
lord,
recording.
my lord, I stand corrected. But 9th August 2024, my lord, the judge's brief along with the affidavit was already filed and the same be kept on record. So this was
Your
done,
Lordship, it has,
and thereafter, my lord, the matter
Your Lordship, we have not been given.
24th September.
The judges brief have served the
My lord, 24th September, when the matter was being cross-examined, when
have you served? When
I
you
have
served, you have
handed
taken
over physically in
You
court.
have taken that.
No, my lord.
So,
But because it was done in court.
No, Your Lordship.
where is the order?
It's called 24th order.
No, Your
Yes.
Lordship, there is a recording on.
Yes.
I am my.
It is
There is a recording, but the thing is, I will indicate one thing. This judge's brief of documents, the examination in chief has been filed and served on us, but I take with responsibility judge's brief of documents has not. It is recorded. I understand. Understand.
I remember
But I understand
categorically
this,
it
but
was
that
given.
is recorded. But what I'm indicating, Your Lordship, there was no point in me taking this kind of frivolous if it has not been the case. Your Lordship, this has been served. It was given to us. This perhaps has been indicated, but we haven't got up judges before documents. We haven't got it.
My lord, the judge's brief, I had handed over the documents.
Yeah,
I'm
my
still
lord,
carrying. I anticipated something like this.
So
I'm
Your
still
Lordship,
carrying.
there is no reason for him to carry if it has actually
No,
been served
it
on.
was for my benefit, but I'm still
But
carrying. I can
anyway,
give a
otherwise also examination.
My lord, may I begin the examination in
Affidavit of evidence, Your Lordship, cannot be filed without the documents.
No, on that day the witness was examined in part. On that day also the witness
the
was
deposition
examined
is
in
there,
part.
my lord. 24th September, deposition is there.
Ah.
9 questions
Yes,
were
witness was examined in part.
And then after while the chief was going on, my learned friend came in, intervened, and indicated that he had
Examined
2
part.
applications.
Deferred till 2nd December.
At least Your Lordship they can give us a copy. I actually don't have. I don't have a copy of the documents. Could you just give us a copy of the documents? Because I actually don't have any
Okay, continue.
Sir, my name is Ram Avatar Kankani. Ram Avatar Kankani.
Resume, huh? Chief resume.
My lord, would it be beneficial if we move to this side because the documents have to be handed to me?
Yes, yes,
Chalo,
absolutely.
Sure. I'm showing you a document. Please.
नहीं अभी मत डाल क्यों डाल अभी ये रहने दो।
I'm showing you a document. Please tell this court what is this document about?
This is board resolution, extract of board resolution, empowering me to appear in this case.
Who has prepared this document?
This is prepared by the board of directors of the company.
Where is the original of this document?
This is original.
Sorry?
This is the original and a copy of this in our record at minutes at office.
The copy of this original is at
In the record of minutes.
the record of minutes at our office.
At our office.
Is there any signature appearing on this document?
Yes, there is a signature of Mr. Ramesh Kumar Ateria, who is the director of the company.
Kumar Rateria. Who is the director of the company?
How are you aware of his signature?
I am working with him since 1997, and in day-to-day course we are seeing his signature on the other paper also. Day-to-day basis.
I am seeing his signatures in other papers also.
What do you have to say about the contents of this document?
The contents are true and correct.
May I tender this document in evidence?
Your Lordship, with objections, because this is not an original document. It itself says it's a certified true copy. At the bottom of the page, your lordship will, where the signatures are
uh,
there, if your lordship will see, there is a certified true copy.
Certified true copy of the resolution. Because
Or he says it's an original document. That is why I'm saying the original would, wherever he has tendered it as an original document. So objection that it is not an original document, it's a certified true copy.
Exhibit A with objection as the document is the certified copy of the minutes and not the original.
Not the original, as tendered.
But I am tendering it as a certified copy.
No, you.
Anyway, I will deal with it when the objections are there. I am showing you a document appearing at page 2 of the judge's brief of documents. Kindly tell this court what is this document about.
This is company master data taken from the Ministry of Company Affairs website by paying requisite fees.
In this master data, which company's particulars are indicated?
Messrs. JMB Polymer Limited.
How have you obtained this particular document?
This is taken from the website of Corporate Affairs, Ministry of Corporate Affairs, by paying requisite fees.
My lord, may I tender this document as Exhibit B, my lord?
Your lordship, with objections, first, whatever tendering, the fee payment and all thing, no details have been provided first. And the second thing is an electronic document, appropriate affidavit with regard to the, not filed.
Exhibit B, subject to objection, as this document is an electronic document.
But I will check if it
electronic document and filed without the affidavit under section 65B of the.
Now it's, I think, 62 or 63. I'll give the section. The section has
changed now.
No, it is old suit.
Oh,
It is
okay.
old
Old
suit.
suit, the old, yes.
Lord,
And your lordship, the other thing is that which we said that about payment of challans, that has not been provided.
And, payment of challan
has not been
as
indicated.
stated by the witness is not appearing in the document.
My lord, there are several documents which are in the compute taken out from printouts. My lord, if required, and in respect of one particular document, I am aware a affidavit has been filed. In respect of the others, if required, my lord will kindly grant me leave. I'll file in the course of the day, or by the next day I will tender it.
Your lordship, at the time.
So thus,
Yes, my lord.
for electronic document, you want to rely the document and wanted to exhibit the document, that has to come within. First, you have to bring the affidavit under section 65B.
Yes,
If
ma'am.
it is the old suit, if it is a new suit, it will be a 61 or 63.
62.
Yes, ma'am.
Correct. It is there. If you not file the affidavit, so the court cannot presume you will file. The court has to take an objection. Then it
Indeed, my lord will record that objection. But insofar as, my lord, I have gone through, there is an affidavit has been filed, but it is in respect of only certain documents. Certain others, the requisite affidavit is not there. My lord, I shall bring it on the next occasion and tender it, my lord.
What?
The 65 in respect of one or two documents.
That's I'm telling. Whatever the if you file the 65, then you have to adduce the evidence that by that way. If you're not file the 65, then it will be taken as evidence with an objection. Then you have to prove that.
And your lordship, we have not been given a copy of this affidavit of.
Sir, it is a part of the plaint, my lord. It was filed along with the plaint. The affidavit.
It cannot be
How it
under
can-
Order 11, Rule 6, my lord.
Give that document, list of documents. List of documents. Order 11, the affidavit of document they are filed now. Order.
May I?
Order 11, 16.
Which page?
Order 11 rules is the affidavit.
এটা আমাদের নেই copy. We have not been, your lordship, we don't have a, it's not part of the plaint. It is with the plaint, they have filed something else.
At the time of filing of the plaint, we have already filed this particular document, this affidavit. My lord will kindly take up paragraph 3. In the paragraph 3, I have already
So you have
indicated.
not taken the evidence to that effect. You have not taken to the evidence to the effect.
Well, I shall,
How the affidavit is to be proved?
well, I shall file a 65B, fresh 65B, and prove it, my lord.
But your lordship, it has to, as you has not felt.
The objection,
as it falls from your lordship is correct. It has to be done in the affidavit of evidence in that way. It cannot be done just by your 65B.
So you have to adduce that evidence,
My lord.
the evidence to that effect.
My lord. My lord, I shall be filing it with a separate affidavit again and indicate.
Sir, you are not
I'm getting, my lord.
understanding. You file this affidavit.
Yes, my lord.
And what is written in this paragraph 3?
My lord, that has to be indicated. Very well.
You're an experienced person. You have done many matters before me. How the electronic evidence is to be brought on record.
My lord, I was trying to
Shortcut.
I shall do that. Very well. Mr. My lord, is my lord marking this as objection, or shall I go through the documents
If
and
you
then
take that evidence, then I will not record
very
that.
well, my lord.
If
I'll-
you
I
not
will-
take the evidence, then I have to record
I will
that.
do that. Mr.
जो objection डाला था हटा दो क्योंकि 65B already on record है. Let's see what evidence is taken.
Mr.
If you are not ready, then you take time.
No, I'm ready.
No, you have not given the instruction to.
I have.
Your lordship also, can I be given a copy of the 65? Because I
give the copy.
Yeah, it should
I
get
shall
a-
give a copy.
Yeah. ঠিক আছে, ঠিক আছে. You give me a copy. I don't have a problem because I don't know which one to object and which one not to.
कौन सा?
No,
Exhibit B with objection किया था, but he is putting some question. If it is going by like that, then objection will not come. So first that exhibit will be taken out. Let the put the question, then I will take the exhibit.
Mr. Kankani, after you have applied for the copy from the Ministry of Corporate Affairs, how did you receive this particular copy on your computer or on your system?
Your lordship, I object to this question because it presupposes that he actually applied.
That's what I'm telling you, are not ready.
Yes. He's presupposing that he's already giving the answer to half the answer.
If my lord permits, I will put questions, he will answer.
No,
My
the
lord.
question itself, I'm challenging the question. The question gives half the answer.
Your question is in your paragraph 3.
I know, my lord.
I put the question.
I'm putting the question.
Your lordship, the question, I am opposing to the question.
Shall
Please, you take. I am taking.
Have you
care of.
got the question?
No.
I have a proof.
Your lordship, this question cannot go in. This question cannot go in. He's
No,
given
he
the
has
answer.
not. He has not stated that he is applied for.
Yes.
Very well. Oh, na last question.
How have you পরের দিন করে আয় দেখে আয় হবে না
of Ministry of Corporate Affairs by paying requisite fees.
Mr. Kankani, from the website of the Ministry of Corporate Affairs, how have you obtained the copy of this particular document?
Your lordship, opposing this also. He's also indicating where he has obtained it from.
He's given the answer.
Digital document, he has to first ask the question where you have obtained it from. The answer has to come.
Yes, he has already answered, my lord. I've gone through the answer.
Yes,
and
yes, yes, yes. Put the question.
The website of Ministry of Corporate Affairs. How have you obtained a copy of this particular document?
Sir, there is a website of Ministry of Corporate Affairs, mca.gov.in, mca.gov.in. There is a search string about any company regarding master data. There we put the company name, suppose JMB Polymer Limited, then the master data JMB Polymer Limited.
Suppose.
Then company master data, their registered office, their director details. Okay. Sorry. Registration detail, their address, their name of directors, etc. came on the screen.
On the screen.
On the screen.
Yes, next.
My lord will kindly keep strike of this answer. My lord will keep it at the previous stage. I will come back on the next day with the particular document. There are certain other 2 or 3 documents, my lord, which are not under 65B. May I proceed with those documents today?
When? Today?
Today.
I don't know, whatever, but you have mentioned the exhibits in the examination in chief.
My lord, in the examination in
Give the
chief, I had
examination chief.
mentioned it as PD 123, my lord.
Your lordship, it should be done in a serially manner. Otherwise, it will cause problems later on in the trial.
Any event it is being marked as ABC.
So PD1.
PD1.
So if you have to go to the serially, then exhibit A, exhibit PD1, and this is also not correct. Exhibit PD1 is not correct.
My lord, it should have been A B C D or 1 2 3.
Let it say me marked as exhibit. Then exhibit will be done by the court.
Very well, lord.
In the examination chief, this is the document. Let the same be marked as exhibit. Then if it is identified, then the court will exhibit this. So what do you want?
Well, I'll come back. There is no point flogging a dead horse today.
Last ki hoche. Last answer.
There is a website.
बस देखो ना ना नहीं do this is not.
Madam, may kindly.
I am not deleting. Let it be witness.
Yes,
Take
yes,
that on doc. Let it be in record. On that exhibit I am not taking. क्या बोलना? So and so appearing for the plaintiff. आप उधर जाइए.
आप उधर.
So and so appearing for the plaintiff. So and so appearing for the defendant. Plaintiff witness is present. And during his evidence, one document is exhibited, being exhibit A with objection. It is counsel for the plaintiff pays for time to examine the witness on the next day. Accordingly, chief is deferred. Let the matter appear on. Give the date. Come ready on that day.
Yes, would my lord please to fix a time, my lord?
On Friday?
Any date convenient.
25th of 24th February at 2 p.m. 24th February 2 p.m.
My lord, can it be 31st instead of 24th?
Huh?
No, 31st.
Any other date? Any other 24th February?
February.
Okay.
Not sure.
Yes, next. Here. पास और कौन आएगा? Yes, again pass हुआ.
No, my lord. My lord, it was a failure in our part. We are already forbidden by the act, my lord. So my lord may pass whatever order he pleases.
Where is Mr. Alim?
He was there a few minutes back. I don't know where is it right now.
So and so appearing for the plaintiff, so and so appearing for the defendant. Counsel for the plaintiff submit that. तो यार ऑर्डर दिया था कहाँ रखे तुम्हें? ऑर्डर ही नहीं रखते. उसको वापस कर दिया ऑर्डर. वाह, ऑर्डर भी वापस कर दिया. वो तो उसका लेटर देने को वापस बोला, ऑर्डर भी दे दिया. बढ़िया. पास हुआ. Let pass and let Arjun come. He has taken the order also.
Number 34.
कोई नहीं है. None appears on behalf of either of the parties. No accommodation is sought for. It is fine from the record the case is fixed today for witness action, but no examination in chief on affidavit is filed and no judge's brief of document is filed. Accordingly, for the interest of justice, the case adjourned. Let the matter appear in the combined monthly list of April 2025. Next.
I appear for the plaintiff in this matter, Millard. Till date, Millard, Millard, as per the report obtained from the department,
Yes.
the writ of summons was served upon the defendant number 1 on 4th of May 2024. Lordship will kindly take the last paragraph. However, computer-generated post-tracking report has been obtained from India Post, item delivered addressee on 4/5 in respect of defendant number 1.
Yes.
Lordship will kindly take now the previous paragraph.
Receive summon along with the print and signature on defendant number 2 on 11 June.
Ma'am, both. was served on 11 June 2024 at about 3:45, 1 and 2.
1 and 2.
So 1 was served even before, so that date will be calculated. In any case, even if we consider 11/6, till date, we have not received any written statement.
There are 3.
There are 2 only.
No, 2 defendants.
2 defendants.
1 and 2. Yes. They are not entered appearance.
I don't think, Milord, as per the
Captain report.
Not report, Milord, but case status, Milord. On the website, Milord, it shows nothing is indicated. Milord, may I pray for this, Milord? Lordship will kindly, Milord, direct the department to file a report, Milord.
You can report.
Very well, Milord. Lordship will kindly give us 2 weeks time.
How much
Milord.
time will take?
2 weeks time, Milord, we will come back with a report.
So and so appearing for the plaintiff. Counsel for the plaintiff has handed over the service report issued by the Deputy Sheriff of Calcutta dated 25th of June 2024, wherein it reveals that writ of summons were duly served upon the defendant number 1 on 4th May 2024 and defendant number 2 on 11th of June 2024. Counsel for the defendant and counsel for the plaintiff prays for time to obtain report from the department to ascertain whether the defendants entered appearance or file written statement. In view of the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 28 January 2020.
Grateful.
Take back. Yes, next.
Your Lordship, I'm appearing on behalf of the plaintiff in this matter. As per the judgment passed on 27 September 2024, an appeal was preferred by the defendants. Here is the appeal court's order.
27 September.
27 September.
Modify the interim order by directing defendant to secure 25 lakhs with the London registrar within 2 weeks from date. In default, the said amount shall be immediately executable. On receipt of the said amount, London registrar will invest the same in the suitable interest-bearing fixed deposit account. Yes, then?
Your Lordship, the order has not been complied yet. Kindly direct this matter for discovery and inspection of documents and for them to secure the amount.
Who is for the defendant?
Your Lordship.
What was the order? 27 September? You are having?
Yes, Your Lordship. Your Lordship, in that order, the additional written statement to the counterclaim, the written statement has already been filed on 20th December. The written statement to the counterclaim has already been filed on 28th December 2024.
Correct. So,
Yeah.
Now, what is the order of 27th? What order challenged under before the appellate court? 27 September 2024. What is the order?
Your Lordship, it's your order for.
भाई ऑर्डर क्यों नहीं रखते हो? मुश्किल है यार.
Your Lordship,
नहीं छोड़ो के बड़ा होएगा. 16. क्या लो लास्ट पैराग्राफ बता. लास्ट पैराग्राफ में हो. Last page.
The defendant was directed to secure an amount of 38,63,500.
38 lakhs.
38,63,500.
Now, the appellate court has modified to deposit of 25 lakhs.
25 lakhs. Yes.
So they are not deposited.
Not yet.
You have not received any information.
Not yet, Your Lordship.
There is any time limit?
No time limit. Right. Within 2 weeks from date.
Where it is?
Your Lordship, in the third third page of the appeal court's order.
Even within 2 weeks from date. 2 weeks, 2nd December.
2nd December.
So what is the they have filed the return statement
Yes. Your
with the counterclaim,
With the counterclaim.
and you file the additional return statement.
Your Lordship, that has been filed.
Where? देखो additional return statement है. Plaintiff is given leave to file additional return statement to the counterclaim within a week from the date after serving the copy to the defendant. है? It's a return statement with counter additional return statement.
I have to check. Your Lordship, I have to check that once.
So there is a direction 22nd November, 1 week. Plaintiff is given liberty to file additional return statement to the counterclaim within a week from the date of serving of the copy of the order, copy of the return statement.
Yes, Your Lordship.
And the department director to accept the return statement subject to scrutiny. You're not aware whether you
Your
filed
Lordship, we were given the given leave to file the additional return
correct.
statement. It has
Have you
been
filed?
It has been filed.
Where
Your
it
Lordship,
is?
as far as my instruction, it has been filed.
Sensation suffering for the plaintiff, none appears on behalf of the defendant. Police counsel for the plaintiffs has handed over the order passed by the appellate court in AO-COM 33 of 2024, dated 2nd December 2024, wherein the Honorable Appellate Court has modified the interim order passed by this court dated 27 September 2024 by directing the defendant to secure an amount of rupees 25 lakhs with the registrar original side of this court within 2 weeks from the date, and in default the said amount shall immediately executable. Full stop. Counsel for the plaintiff, none appears on behalf of the defendant. Counsel for the plaintiff submit that in spite of the order passed by the appellate court, the defendant has not deposited the said amount. Full stop. Counsel for the plaintiff further submit that the defendant has filed written statement along with the counterclaim, and the plaintiff has already filed additional written statement to the counterclaim. In view of the above, the parties are directed to complete the discovery and inspection of the documents within 3 weeks from date. Full stop. Affidavit of admission and denial of the document be filed within a week thereafter. Full stop. In the meantime, the parties are directed to exchange the suggested issues. Full stop. List the matter on 11th of February 2025 for framing of issues.
Obliged, Your Lordship.
Next.
Item 37, Malad. I'm for the plaintiff. I'm led by Mr. Mitra Malad. Here, the application has been disposed of. The defendants were present, Malad, at the time when the application was disposed of. We have got a report, Malad, from the Sheriff's Department, Malad. The report, it appears that 2 to 7 all have been served. One has also been, Malad, served because it was the door was locked. That was the remark in respect. And the interlocutory stage, Malad, all the defendants had appeared. This is, Malad, the order of the by which, Malad, the interlocutory application was disposed of.
Yes, 5 and 6.
Malad, 1 to 5 and 6, Malad, all the defendants had appeared.
Yes.
Now, from the report, Malad, of the sheriff, Malad, it appears, Malad, that service was done in April 2024. Though, Malad, door was locked, but it was the correct address.
Served on 1st April upon the defendant number 6.
6.
And 7.
6 and 7. Now, Malad.
Service attempted on itna to 2, 3, 4 for door was locked and served by affixing at the address.
Yes, that's, Malad, service.
It appeared that non-available, not
Report not available, defendant number 1.
Report is not available for the defendant number 1.
Now, my lords will see the postal department service to postal department. The next box, my lord,
Packet with demand door locked.
with remarks door locked for the defendant number
Door
1.
locked, defendant number 1. Undelivered packet of the defendant number 2. Neither postal acknowledgement nor the undelivered packet for the defendant number 6 for both address. Tracking report shows that address C, item delivered to address C. That is 6 and 7.
6 and 7.
So what about the 1?
Well, I'm led by Mr. Mitro, my lord.
So far as 1 is concerned, Lordship, it seems like this was sent to the same address as in the petition, injunction petition, where it was accepted. But now this time door lock. It is not that the addressee left or not found. So door locked is as good as, I would say, unclaimed. This is, I mean, there are judgments for unclaimed, there are judgments for left or refused. But door locked is a new expression for which there are no judgments as yet. But the Lordship, by abundant caution, my lord, what I'm saying, if we publish a paper publication in Madras, because they are in Madras, and Lordship keeps it an undefended suit. If they appear, their Lordship can consider paper publication and fix the date for all. For all of them. For all of them, paper publication will be for all. Of the suit.
Yes.
We can't wait only for one.
So and so appearing for the plaintiff. None appears on behalf of the defendants. Counsel appearing for the plaintiff has handed over the service report issued by the Deputy Sheriff of Calcutta dated 2nd January 2025, wherein it reveals that the writ of summon writ of summon upon the defendant number 6 and 7 was served. As regard the writ of summon upon the defendant number 1, 2, 3, 4 and 5 was not served as the door was locked. Full stop. Counsel for the plaintiff submit that these writ of summons were served upon sent to the defendants at the address mentioned in the cause title, and in the interlocutory applications the defendants have appeared in the matter, but the writ of summons could not be served. Accordingly, he prays for substituted service by way of publication. Accordingly, the petitioner is granted leave to serve the writ of summons by way of substituted service by publication in the English daily newspaper, which were namely which Hindu paper? Hindu or Delhi?
In Chennai, Lordship, I will check up and give it to my lord's office.
Yeah, which is namely so and so, which is widely circulated in Tamil Nadu. It is what is the address?
Chennai, all in Chennai.
Circulated at Chennai, not Tamil Nadu, at Chennai. Circulated at Chennai. The plaintiff is directed to take appropriate step within a week from date. Probably then what are the dates?
Kindly not record not served. My submission is that this is deemed served by abundant caution. Don't say my submission is not served. This is according to me service. Because if not, because not claim their judgments, it is served.
Submitted there. It was counsel for the plaintiff.
Service report issued by Deputy Sheriff Calcutta dated 2nd January 2025, wherein it reveals that the writ of summons upon the defendant number 6 and the was served as regard the writ of summons number 1
no was as per the service report of the Deputy Sheriff, it was found that the door was locked
and unclaimed.
Locked of the service of the
others were unclaimed.
Report, it found that the door was locked and the notice was pasted in the door. Counsel for the plaintiff submit that door lock and pasting of the writ of summons, notice of the writ of summons at the door is good service.
But still, I'm praying
good service. But still, the learned counsel for the plaintiff submit that for the abandoned caution abandoned counsel, the plaintiff may be allowed to publish the notice for the information of the defendant. हो जाएगा, हाँ? Yes, next. Yes, where is
Yes, my lord. I appear for the plaintiff. A plaint served on 2nd of November.
Where is that? Where is that?
It's recorded in my lord's last order. I have the copy.
Which order? Order dated?
Lord, order dated 6th of December. We had served the amended plaint 2nd of September. 120 days expires on 2nd of January 2025. And I had also handed over an email, my lord, where they had waived the issuance of writ of summons. So that is why we had
That's
given.
why, where is the order? The waiving.
Oh, order of waiving. Lord, just a minute.
That I am searching that order. That is not in record.
Lord, order dated August 30, 2024.
So appearing for the defendant, plaintiff, so appearing for the defendant. Counsel for the plaintiff submit that the learned counsel for the defendant has accepted the writ of summon. And as per the prayer made by the counsel for the defendant, this court has waived for lodging of writ of summon and directed the plaintiff to serve the copy of the plaint along with all the documents in learned advocate appearing for the defendant. In compliance of the order dated 30th August 2024, the plaintiff has served the copy of the plaint along with all documents to the learned advocate appearing for the defendant on 2nd of September 2024. Full stop. The counsel for the plaintiff submit that in spite of receipt of the writ of summon copy of plaint along with the documents, the defendants have not filed written statement till date, though time to file written statement has been completed. Full stop. Learned counsel for yes, what is your submission? Okay, full stop. It is fine from the record. The plaintiff and the defendant, the learned advocate appearing for the defendant has received the copy of the plaint along with the documents from the learned counsel for the plaintiff on 2nd September 2024. On 2nd of January 2025, 120 days, that is the outer time limit for filing the written statement is over. But in spite of, is over. Until date, the defendant has not filed written statement. In view of the above, let CS Com 456/2024 within bracket old CS 11 of 2023 be placed in the list of undefended suit.
Just one indulgence, wherever my lord has mentioned plaint, your lordship may kindly mentions amended plaint because there was an amendment.
Amended plaint. On 2nd September 2023, plaintiff has served the amended plaint along with the document. Copy of the amended plaint along with. Okay. The full stop. The plaintiff is directed to file judge's brief of document after serving the copy to the learned counsel for the defendant within 2 weeks from date. Full stop. The plaintiff is also directed to file the affidavit of evidence within a week thereafter. Full stop.
Instead of 2, can it be 3, my lord?
3 weeks. File judge's brief of document. File judge's brief of document within 3 weeks from date. Affidavit of evidence will be filed within a week thereafter. Full stop. List the matter. Give the date. 25th of February 2025 at 2 p.m. for witness X.
Extremely great.
2025 at 2 p.m.
2 p.m.
for witness X. Yes, next.
No,
yes.
From the earlier order, my lord, where your lordship was pleased to relegate the matter to trial, my lord, now my learned friend's client has preferred an appeal.
Any stay?
No, my lord,
There's no stay, but the matter will be taken up on Monday.
On Monday for final hearing.
For final
But
hearing.
This is an application.
You're not prepared.
My lord, tribal issues, so we are ready and willing to go for the trial. But
This was the intention.
my lord, legality has to
Yes,
be
yes,
weighed.
I'm not saying anything.
So, my lord, it's fixed on Monday. So it could, if this matter could stand over for a fortnight.
Suffering for the plaintiff, suffering for the defendant. Full stop. It is submitted by the learned counsel for the respective parties that the plaintiff has already preferred an appeal against the order passed by this court dated 18/11/2024. 2024. In view of the above, for the interest of justice, the case adjourned. Let the matter appear on 10th February 2025.
Great.
Grateful.
My lord, both are similar matters, my lord.
Same order.
Great.
38, 39, same order, huh? 40.
Lordship, I'm appearing on behalf of the plaintiff in this matter.
Yes.
Your Lordship, writ of summons along with a copy of the plaint has already been served upon the defendant in this matter as per the mode of service.
How many defendants?
Your
One.
Lordship, only one.
Have you got the report?
Yes, Your Lordship.
Anybody appearing for the defendant?
Your Lordship, defendant has entered into appearance.
Then WS filed.
No, Your Lordship, no WS
Or
has
return
been filed.
statement is filed. When they have entered appearance, May.
Yes, Your Lordship.
And writ of summons was served April. No return statement.
No return
Have you
statement,
obtained
Your
report?
Lordship. Yes, Your Lordship.
When you will adduce evidence? Witness present?
No, Your Lordship.
Sons appearing for the plaintiff. None appears on behalf of the defendant. Police counsel for the plaintiff has handed over the service report dated 22nd of July 2024, wherein it reveals that writ of summons was duly served upon the defendant through bailiff as well as postal service on 4th of April 2024 and 6th of April 2024, respectively. Full stop. As per the report of the Deputy Registrar Legal dated 29th of July 2024, the defendant has entered appearance on 21st of May 2024. Full stop. The report issued by the Deputy Registrar Legal dated 31st of July 2024, it reveals that no written statement on behalf of the defendant has been filed. Full stop. Considering the above report, this court finds that the defendant has not filed a written statement within the prescribed period of 120 days, within the outer period of 120 days. Accordingly, the CS Com 567 of 2024 is required to be placed in the list of undefended suit. Accordingly, full stop. Let CS Com 567 of 2024 be placed in the list of undefended suit. Full stop. Sapara. The plaintiff is directed to file judge's brief of document within 3 weeks.
3 weeks, Your Lordship.
Within 3 weeks. Full stop. Affidavit of evidence of the witness of the plaintiff witness be filed within a week thereafter. Full stop. Please the matter. Give the date on 25th of February 2025 at 3 p.m. 3 p.m. for witness action.
Obliged.
Come ready, otherwise cost.
Obliged, Your Lordship.
The reports be kept with the record. The reports be kept with the record. Yes, next.
My lord, I am appearing for the plaintiff, my lord. This is a plaint, my lord, filed against my lord repudiation of my client's claim, my lord, on the basis of insurance policies. My lord, the summon in this matter was served. There is only one defendant, my lord. The summon was served on 11th of September And my lord, the plaintiff's advocate has entered appearance on 7th of November.
Plaintiff or defendant?
Defendants, my lord. So, my lord, the 120 days, the statutory period, my lord, is expiring on 9th of January.
That's right.
From the date of.
And I will file
appealing?
before that.
Yes.
I'm
You are waiting for a 120th day.
my lord, my instructions have come late. My lord, we will file it before. And my lord, may I have you file the wakalatnama? Wakalatnama is
File
filed
the
in the
application, my lord. File the application for extension of time.
Yes,
sir.
I shall.
You
do the
wait till 9.
Yes,
Then
yes.
we'll see.
I shall do the needful, my lord.
So and so appearing for the defendant, so and so appearing for the plaintiff, so and so appearing for the defendant. Police of counsel for the defendant submitted. They have already taken steps for filing written for extension of time to file written statements. In view of the submission made by the counsel for the plaintiff submitted. Okay. This by the counsel for the defendant, the case is adjourned. Let the matter appear on when 9th of January.
9th of January, the 120
Let the
days.
matter appear on January 2020.
Has taken steps or is taking steps, my lord?
Going to take steps.
Obliged.
Great for my lord.
IPA for the plaintiff till date, received any written statement.
We have.
And we do not.
FPA for the defendant in this matter.
I also do not know whether the written statement.
Some problem with the video. I have some problem with the video, Your Lordship. That's why. There's some problem with the video, so that's why there's some technical glitch which I find.
I also.
So Lordship will kindly allow me to. The written statement has been filed with the department. Your Lordship has recorded in the order of 12th of November 2024, where Your Lordship has imposed cost upon us, and Your Lordship has allowed us to file written statement. So we have already paid the cost, and written statement has already been accepted long back by the department.
That is
now the formal directions for admission, denial, and discovery has to be given.
No, my lord. If that is the stand of the respondent, my lord, they will be in further difficulty. Lordship will kindly see the written statement who affirms it, whose backsheet it is filed with, and who has filed it. Devjani Shengupta.
Also, Banerjee's. Yes.
Lordship will kindly take the backsheet.
Now the change has been obtained.
Very ground. Lordship will now take the order of 12th of November. The very ground was that there was a change of advocate. Thereafter, upon
further, there has been a change of advocate.
Let them
further.
No.
What do you have to do with that?
And statement is admitted.
Lordship
yes, pursuant to the order.
12th November's order. They say that because the erstwhile advocate could not file it, so we have taken change and now filing the written statement. Now that erstwhile the written statement is filed in the back with the backsheet of the erstwhile advocate, and that also in the department also it is shown in the on the website it is shown with the erstwhile advocate.
No, my learned friend is confusing himself. There was some other advocate earlier. Thereafter, it has been changed.
Why I say this?
What you are objecting for?
Therefore, if that be so,
see, this court has already on 9th of September. This court has already admitted the 19th of September. This court already accepted the written statement.
That was taken on record, subject to application. Yes,
that is already allowed. I think so.
But on 12th.
Yes, is allowed.
On 12th of November, Lordship had taken up the application for extension of time. Thereby, Lordship had allowed this application.
Correct.
Yes. In the application, Lordship had recorded that since their submission that their erstwhile advocate on record could not file. So therefore, they have taken a change and now it is being filed by the present advocate on record. Now, Lordship will see the erstwhile advocate on record has in fact filed the written statement. So this order, therefore, was obtained by. If there is no other.
No, my learned is confusing himself. He's not aware of the fact.
If they can clarify that there was also another advocate.
I don't have to clarify you. I don't have to clarify you.
No, to the court.
There was some other advocate the documents were given.
If you both continue to argue, then I am going that first you argue about the matter from themselves, then the court will go. Then when your argument will completed, this court will come.
No, Your Lordship, I will not. I think he was misleading the court. That's why he wanted to clarify.
The court is not so full.
Grateful, Your Lordship.
You are the senior person.
I will not say anything. Your Lordship will take care of this.
Yes, if you have any objection, you file application for take appropriate steps. If they have taken the order by fraud,
Yes, I mean, that is my, because on the on what
not
appears,
because
what
see, making a submission, this court cannot recall the order.
obviously what appears from the documents,
You
that
take,
is what I'm
you
submitting.
take steps if they have done so. If you have done anything fraud before this court to obtain
But it
the,
appears to be so. If there
So
is
you
no
take
other advocate
steps.
on record, my lord, then
you
this
take
must have
steps
been
that they will clarify that. Any counterclaim? No.
No.
So and so suffering for the plaintiff, so and so suffering for the defendant. Will the counsel for the plaintiff submit that by an order dated 12th of November 2024, this court has accepted the written statement subject to payment of cost of rupees 10,000. Will the counsel for the plaintiff submit that the defendant has obtained the order for acceptance of written statement only on the ground that due to change of advocate on record, the written statement could not be filed. But the written statement, the written statement which the defendant has now filed is of the erstwhile advocate, and as such, from the face of record itself shows that the defendant has obtained order dated 12th of November 2024 by playing fraud. Full stop. This, considering the submission made by the counsel for the plaintiff, this court is of the view only by way of submission. This court cannot go into the fact. The plaintiff has a liberty. If they choose to do so, they can take appropriate steps for recalling of the order dated 12th of November 2024. Full stop. As the defendant has filed the written statement, accordingly, the parties are directed to complete the discovery and inspection of the document within 3 weeks from date. Full stop. Affidavit of admission and denial of the document be filed within 2 weeks thereafter. Full stop. In the meantime, the parties are also directed to exchange their suggested issues. List the matter on 7th of February. No, 4 weeks. 3 weeks, 2 weeks, 5 weeks. No? This is the matter on 17th of February 2025 for framing of issues.
Grateful, Your Lordship. Extremely.
Next.
Item number 1 and item number 2 of the non-commercial.
Yes.
So this is the South Point School matter. South Point School matter, it's a question of 16th April 21, whether it's a valid circular resolution. If it's a valid circular resolution, then their case has a ground to stand. If it does not, their case goes, and they can't wrongfully, illegally hold on to the office of or to the control and management of this South Point School. This is the long and short. What you may recall, just to brush up, since this was some time back, 16th April 21 is at page, what should we be looking at? CS 171.
Yes.
CS 16.
CS 16.
Page 171. Volume 2, page 170. কি সব কাগজ দিয়ে যাচ্ছে, হ্যাঁ বার করো ও কাগজ দিয়ে যাচ্ছে শুধু পিটিশনটা কোথায়?
Volume 2 time.
Yes, I page 170.
CS 16. CS 16.
CS 16 GA1.
GA1.
Page 171. The
171.
page 171.
Yes.
The circular resolution, third paragraph, the first two well, the second paragraph itself is from the very first paragraph. The society is in receipt of various communications at 12th November 20, 27th February 20, from the office of the Joint Administrators Pendent Light. This is the harbinger of things to come. You are aware that during the lifetime of Srimati Priyambada Birla, she was a trustee as well as president of the governing council. Or she may recall, the third paragraph is very important. I had placed it. After the demise of Srimati Priyambada Birla, various disputes arose in connection with the succession and extent of the estate of late Srimati Priyambada Birla, and the same are still pending before the probate court at the Calcutta High Court. Late R.S. Lodha, who had propounded a will of Priyambada Birla, bequeathing her entire estate to him, was already a trustee and vice president of the governing council at the time of her death and became the president soon after her death. Her son Harshvardhan Lodha became a trustee and governing council member in September 23. Sri R.S. Lodha passed away in October 8, and after him, Sri Harsh Lodha, who was an interstate successor of R.S. Lodha, as one of the claimants to the estate of Priyambada Birla, later became president of the society, very important, by a set of judgments and orders, including judgment and order of 23rd August 2012, passed by the division bench of the Honorable High Court of Calcutta. A 3-member committee was appointed as administrators pendenti laiti for the purpose of administration of the estate of Priyambada Birla, to exercise the rights, powers of general administrator over the estate of Priyambada Birla. The APL committee, they constitute of these persons. On 29th November, on 2nd November 2020, society received a communication from Khaitan and Company, advocates for defendants. There's no litigation at that time. They're possibly mixing up the probate suit with this, enclosing the following decisions, judgments, and orders. One, decision of the APL committee, 19th July. Actually, 30th July 2020, APL committee. Then judgment of 18th September 2020 of the division bench and the 1st October 2020. The next paragraph is very important again. The letter dated 12th November 2020 received by the society from the APL committee, copy attached, contains judgment and order of 18th September 2020 and the 1st October 2020. Passed in the matter of the probate proceedings. The letter of 27th February 21 received by the society from the APL committee informed that the APL committee at its meeting held on 26th February 21 has decided by majority to nominate the following persons for being appointed as trustee, whether they had any authority or not. Now, these two persons are named. Consider next paragraph. The APL committee in the above letter dated 27th February 2021 has also stated that the existing trustees, governing council, managing committee members of the society do not include, the APL committee stated, do not include Harsh Lodha anymore on account of the judgment dated 18th September 2020, read with 1st October 2020 of the Calcutta High Court. Next paragraph is not important. The opinion of Justice Ashok Ganguly, that's also not, well, we can't take opinions of anybody else before your lordship. In view of the above, your consent is hereby sought on the following resolutions, which are intended to be passed by circulation. Resolve that cessation, very important, cessation of Harshvardhan Lodha as a trustee and president and member of the governing council of the society, consequent to the judgment of 18th September 2020 of the Honorable Single Judge of the High Court and the order of 1st October 2020 of the Honorable Division Bench of the Calcutta High Court, passed in the matter of the probate proceedings in respect of the estate of Priyambada Devi Birla as communicated by the office of the joint administrators pendentility of late Priyambada Birla by their letters of 12th November 20 and 27th February 21 be and is hereby noted and confirmed. So, well, this and the other two follow. Or should may recall, I'm just summarizing my submission. What Mr. Bachawat also submitted is, comes 18 September 2020, a judgment of the learned single judge.
Correct.
Where his lordship held that there are
APL.
there are some paragraphs which says has no power, but at the end there is some observation that APL guidance and directions will be followed by not only the parties to the suit, but all so-called MP Birla group entities, which was also mentioned to include trusts and societies. This was the order of 18 September 2020. From that goes up and we go up in appeal. On 1st October 2020, an interim order is passed restricting the APL's role and Harsh Lodha's disqualification only to those offices which Harsh Lodha held on the strength of the shares owned by the estate. That would have included 5 companies, which we have troubled your lordship, where the estate had the majority shareholder.
Correct.
And so that was made clear by the division bench. After this comes the next order comes this of April 2021 by the same division bench in contempt proceedings, when the defendants and also APLs also joined, took this while the contempt petition against Harsh Lodha and Harsh Lodha for discharging function as director.
Holding the meeting.
Huh?
Holding the meeting.
Yes. For holding directorship or for the four manufacturing company.
Correct.
Saying that Mrs. Birla's influence extended. The contempt was dismissed. Then comes the final judgment where the division bench is clearly held.
The probate.
Only what is there in the affidavit of assets.
That is the only.
The influence which she had left with her, and nobody inherits the influence which the person which she had. Now, after the 1st October 2020 judgment, it appears when it was made clear that only under the strength of the shares, the APL, 2 of the APLs in November 2020, that is the last page of page 172, last 2 lines of page 172, 2 letters of 12th November 2020 and 27th February 2021, told some of the trustees that by virtue of the order of the Harsh Lodha has ceased to be a trustee.
Correct.
Which by no stretch of imagination could be interpretation of the 1st October 2020. It is like saying yes means no.
Yes.
Not may means shall, but yes means no. But that communication, on that basis, this circular resolution is passed without giving notice to Harsh Lodha, not for removal of Harsh Lodha, but for recording that he has ceased to be. So, my lord, thereafter, my lord, this was never communicated to Harsh Lodha. Thereafter, what happened was, whole thing changed after the division bench judgment, and in March or April 2024, one of the persons who were claiming control, who was being blessed by two of the APLs, was Mr. Krishna Kumar Damani. He's arrested, and newspapers are flooded with reports of
Forgery.
Defalcation of funds from the trust, from the South Point School by this Krishna Kumar Damani, one of the other trustees. So, Harsh Lodha immediately convenes a meeting of the trustees by giving notice to whoever were the trustees. Because prior to minus this circular resolution, which included 2 of their persons, Mrs. Damani, Mr. Daga also. Mr. Damani is behind bars, Daga doesn't attend the meeting, and at that meeting, we decide to appoint some new trustees and managing committee members in society. Now, this is what is really under challenge. And now we are saying that in spite of this, those persons who are imposters, they are not making over.
So which are the characters?
In between comes one in between event is in May 2024, when in another of these societies, a similar thing happened. There, instead of 16th April 2020, it was 4th April 2021, 4th March 2020, where the other side filed a suit saying that they are challenging the action of Mr. Harsh Lodha and the existing trustees by saying that they have ceased to be trustees. So, where Justice Sarkar, after analyzing the division bench judgment and the provision, said that this is inoperative. 4th March 21, it is equivalent is 16th April.
16 April.
Well, and the third development is this: when another of the societies, when a similar suit was filed, Mr. Chidambaram had moved, where we had relied upon the 4th March order, Lordship following 4th March order, at the ad interim stage on 22nd.
Order was 22nd.
By relying upon the 22nd May order of Justice Shampa Sarkar, said that you don't have any prima facie case for any interim order. From that, they filed appeal. This was order passed in 21st June 24 by your Lordship. From this appeal preferred, appeal withdrawn. And so far as Justice Sarkar's order of 22nd May 2024, they have filed appeal. They have not got any stay.
Pending.
It is pending. Now comes in between certain further developments, as in the. Right, that is my mistake. So the new trustees on the basis of 16th April versus the original trustees have filed this case. Now, I had shown these. I had placed the affidavit of assets. I had placed the revision bench judgment. I had placed the inventory report of the.
Yes.
Now I want to show now today the averments in the plaint on the basis of which this suit has been filed by them. Kindly come to volume 1, page
of GA1.
GA1, it is the same as the plaint. Paragraph 3, page 4. The respondent number 1, as you can see, knows what is their case. Their case is based on the 16th April, and that in turn is based on the 18th September order. I don't know how they can do it after the 1st October and after the division bench order, where this order was completely undone. They can rely upon the trial court's order. Paragraph 3, page 4.
Yes.
The respondent number 1 was a trustee and president of the and member of the governing council of society until 16th April 21, on which date he ceased to be a trustee and president of the governing council in terms of resolution passed by the board of trustees on the said date, pursuant to the order of 18th September 2020. Between 16th April 21 and 18th September comes 1st October 2020 of the Honorable High Court of Calcutta. The said resolutions remain unchallenged in any judicial proceedings till date.
Said resolution remain unchallenged in the judicial.
This was firstly never served on Harsh Lodha to challenge, and secondly, what is void? Contrary to an order of court, I don't need to have a challenge to, because if it is completely void, and when you have to make out a case, when the plaintiff is making out a case on the basis of 16th April 21, they can't create one resolution and say that this has not been challenged, so you have to accept it. They have to show prima facie how this is a valid resolution. Otherwise, anybody will just type out a printed piece of paper dated 2 years, 3 years back and come and say, my case is based on this. This has not been challenged. You have to show how it is valid. Then what you kindly see is paragraph 4, page 5, just above paragraph 5, the last 8 lines of paragraph 4. With effect from 16th April 21, when the respondent number 1 ceased to remain a trustee. The last 8 lines of paragraph 4, just above paragraph 5. With effect from 16th April 21, when the respondent number 1 ceased to remain a trustee of the society and member of the governing council, the respondent number 2 also stopped participating in the meetings. So my cessation is said to be 16th April. That is the circular resolution.
So that's why they have recorded in the meeting.
And this is the way paragraph 8 also same thing. So the entire case is based on 16th April 21, paragraph 8.
So they have taken the stand. You have not challenged this resolution.
Because we have not challenged it, so it is deemed to be valid. So firstly, the most important thing is it's never been served. They have not shown that it's been served on me. Either the resolution or the subsequently this was given. No. Number 2, when you are making out a case based on a particular resolution, you must show it is valid. Otherwise, anybody can create a resolution and say since removing, as I said, they gave a very kind of a.
But once you have been removed in terms of the resolution, you cannot challenge that.
That is the whole question. Whether I have been removed in terms of the resolution.
That is the cessation.
Whether cessation has happened in terms of the resolution. Otherwise, today I can pass a resolution with Shomura Chaudhary removing the Mr. Mukesh Ambani as director of Reliance Industries. And then somebody files a suit saying that you have not challenged it. But it has to be removal. Has to be removal. On account of the order seized. And they are not removed. But you should kindly note one. Well, they're not removed. There's a provision for removal. They're not removed.
Yes, you have shown that.
They have said, I've ceased to be a trustee. Cessation.
Account of the order.
On account of the order of 18th September. That order 18th September was not there when the resolution was passed 16th April because it was modified. That part was modified on 1st October.
Yes.
Now, so the plaint case, then paragraph 8, then it goes on. Everywhere this is based on 16th
April.
Yes.
Their main case is on 16th April.
Now I'll come straight away to the to a few more files before I come to the judgment. What they are saying, who are the trustees, kindly come to paragraph 9. Paragraph 9, page 6. The present valid composition of trustees and the governing council of the society are as follows. Trustees Jhaveri, Rameshwar Singh Thakur, both appointed later on the basis of 16th April and those post 16th April.
They are the nominees of the APL.
Then Sushil Daga original, Krishna Damani, Vishwajit Motla. They were the original ones. Now they should have shown Krishna Damani. Show me the order. Bail order. Krishna Damani has been discharged on bail sometime in May 2024. Copy now. On the condition that he can't act as trustee. The second last paragraph. Considering the facts and circumstances of this case as well as decision of the Supreme Court, the accused person Krishna Damani may find bail of 5,000 rupees with a direction to not leave residential jurisdiction, not important, to meet investigation officer. Number 3, not to enter within the jurisdiction of the
school or interfere any affairs of the work of the school.
Not to enter the jurisdiction of the school to or interfere any affairs or work of the school or the society in any manner. I'm told number 1 has been relaxed afterwards. He can leave his residential jurisdiction, but number 3 has remained as it is. So he cannot enter jurisdiction of the school or be involved in the affairs of the society. So he cannot discharge the function of a trustee or a governing council member, which Justice Shampa Sarkar's judgment had anyways held. Since he has been convicted, he should not be allowed to function as trustee. That was Justice Shampa Sarkar's order. So now this is the one. And Lordship, I want to show, my lord, before I just place a few judgments. It is the plaintiff here is so strongly advancing the case of Krishna Kumar Damani. That's also a very surprising part. Somebody who has defalcated funds, at least there is a charge sheet against him. I admit there is no conviction as yet, but there is charge sheet against him. Petition. Now, I will just show from the affidavit in reply filed in the that when the person who's a trustee, the other governing council member, not just of the opposition.
In GA2, my petition.
In my petition, Lordship kindly comes to GA1, the affidavit in opposition in GA1. Sorry. Affidavit in GA2.
GA2, affidavit in opposition.
Yes. Well, GA2,
10 to 30.
affidavit in opposition in GA2. Page 9.
Page 9
of the affidavit in opposition in GA2.
Affidavit in opposition of Siddhartha Mitra.
Of Siddhartha Mitra.
6th May.
I'll tell you, 6th May, because my
Why
chance
Siddhartha
is 6th May possible. Kindly see page 9, if it is paragraph 10A.
10 capital A.
10 capital A, page 9. Page 9.
Where I have alleged against.
Paragraph 10 capital. With reference to allegations contained in paragraphs 10 to 13 of the said application.
Yes.
I deny that prior to April 21, Krishna Damani had siphoned out funds from society to the sole concern by the name of Global Staffing Services, which is a unit of Pastille Mercantile Private Limited as alleged or at all. Or should I deny the contents and validity and legality of the remand report in 9th of the police. Referred to a paragraph. I say that the payments made to Global Staffing Services and or its predecessors were against contracts entered into by the two schools of the society with the said service providers in respect of outsourcing of various contracts entered into by the two schools of the two society with the said service provider vendors in respect of outsourcing of various services. Lord, kindly pause here for a moment. Before I, my officer, petition. Kindly see GA2. What are they dealing with? In GA2, paragraph 10. Kindly come to, yes, page 8 of GA2. This Krishna Kumar Damani outsourcing, there's nothing wrong. Kindly see paragraph 8. That's page 8.
Paragraph?
Page 8.
10
Page 8
10
of
to 13, yes.
10 to 13.
Post arrest of Krishna Damani.
It was discovered that he had in fact since April 21 siphoned out funds from the society to a sole concern by the name of Global Services, which is a unit of Pastille. Manju Damani, mother of Krishna Damani, and Jaya Damani are directors. Copies of remand report is so and so. Krishna Damani, as a matter of fact, has. So it is to a society. He forms a company where he makes his mother-in-law and wife directors and outsources schools contracts to that society and makes profit without. And this the present Siddhartha Mitra is supporting.
How has he affirmed it just?
And
yes,
I will.
कल मंडे नहीं है ना? How much time you will take, Mr.
I will take half an hour. I will just show some more judgments and finish.
And only one thing, Malad, we were denying all these things. We did not support it. We denied his allegations. I think he should have said that. It was a denial, not support.
Very well, very well.
If you will
allegations of it.
you will admit, then you will be one of the witness.
Malad, that is what I thought, Malad. I don't know what's falling from him.
Then I should place them more carefully, Mr. Ray. I should place them more carefully then.
Yes.
Carefully.
सुन लिख देना, नाम सब लिख देना. Senior counsel Mr. Abhijit Mitra had argued at length, but due to paucity of time, hearing could not be completed. Accordingly, case is adjourned. Let the matter give the date. Last week, February.
Give 2-3 days, because after I finish, they can also continue. Then it can be some consecutive dates if possible. Then also I don't have to. I can just it'll be quicker.
26, 27, 28. What time? 26, 27, 28 February 2025 at 2 p.m.
Huh?
February. Before your
data. Oh.
27, 28. 26, 27, 28. Feb.
I will finish off within the first day so that Mr. Mukherjee can.
So 3 dates, you can finish it.
3 days won't be enough, my lord. I know. So if you kindly give 2 more days so that we can finish it up together. Some continuity.
Third or fourth March? 26, 27, 28.
Third March for the Holi.
2 p.m.
That's tomorrow.
2 p.m.
So that this 5 day completed. So by April the judgment can be.
My lord, kindly
to
mention a matter, my lord. Your lordship
26
has been pleased to fix the matter on the 7th, but the interim order is still the 3rd. Mr. Rai Chaudhary is here. Now, this is that contempt matter. Contempt. Infringement and passing of suit. By the order dated 9th December, your lordship was pleased to extend the interim order till 3rd. And the next day, the contemners appeared and the matter has been fixed on the 7th. But the interim order is expiring today.
So let's come on 7.
Well, the interim order is expiring today.
Since suffering for the plaintiff.
My clerk and peon are not allowed to touch my brief.
But the learned counsel for the plaintiff submit that the interim order for the earlier is going to expire today and wait for extension of the interim. Counsel for the plaintiff submit that the content matter is listed on 7th of January.
Both the matters.
Submitted that the matter is listed on 7th of January 2025. In view of the above, the interim order is extended
Volume 1 and 2.
Till 14th of January 2025 or until further order, whichever is earlier.
Great.
As supplement.
Therefore, I am doing the same thing.